Justice of the Appeals Court, now sitting in Boston, far and within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milky. To my right is Judge Shin. To my left is Judge Englander. And together we are your panel on the 6 cases we're hearing this morning. Now, it appears that some of you are under the impression that we're handing out free food. I can assure you that that is not accurate, and if it were accurate, it would be food that only a career state employee like me would enjoy. With that, I understand my colleague Judge Shin has something to say.
Yes, thank you, Justice Milky. As many of you know, after over 15 years of service on the Appeals Court, Justice Milky is sitting today for the final time before his retirement in September. In honor of the occasion, I would like to say just a few words about my friend and colleague, Jim Milky, and then I'll turn it over to Justice Englander, who will also say a few words. Before I begin, I wanted to acknowledge some guests in the audience. First, Justice Milky's family, his wife, Kathy Martin. I don't believe their son, Julian, is here. Justice Milky's sister, Joanne Ertel, who I understand is herself a retired judge. His brother, John Milky, and his niece, Camille Ertel. Supreme Judicial Court Justices Dalila Winlant, and I think Gabrielle Woolhogen, there she is. Appeals Court Chief Justice Mark Green, Associate Justices of the Appeals Court, too many to name, members of our excellent court staff. I understand some of Justice Milky's former law clerks are here. Oh, I see some of them. And I see some of his former colleagues from the Attorney General's office. So, what can I say about someone as colorful as Jim Milky? While I'm sure his family has many interesting stories from his childhood, in the interest of time, I'll fast forward a bit to the start of his legal career. After graduating from Harvard Law School magna cum laude in 1983, Justice Milky began his career here as a law clerk to Associate Justice Benjamin Kaplan. Following his clerkship, he crossed the street to join the Environmental Protection Division of the Attorney General's office, and he became chief of that division in 1996. Embodying what it means to be a true public servant, Justice Milky spent 25 years in the Attorney General's office serving the citizens of this Commonwealth. He was then nominated to this court by Governor Deval Patrick, and he officially joined the court as an Associate Justice on April 8th, 2009. I have now had the pleasure of being Justice Milky's colleague on this court for almost 8 years, but he and I were colleagues previously as we overlapped at the Attorney General's office for 4 years. We never crossed paths, at least not that I'm aware, but I, of course, knew who he was, not just because he was chief of the Environmental Protection Division, but also because he was the attorney in our office who argued and won the case of Massachusetts versus EPA before the United States Supreme Court. One cannot overstate how much time, preparation, and skill it takes to deliver an effective argument to the Supreme Court. This is what Harvard Law School professor and noted Supreme Court scholar Richard Lazarus had to say about Justice Milky's argument. Quote, Jim Milky was a career attorney in the Massachusetts Attorney General's office who presented oral argument for the petitioners in the case, which included several dozen environmental groups and about a dozen states, territories, and local governments. Milky's oral argument in Massachusetts versus EPA was, simply put, one of the best Supreme Court arguments I have ever witnessed, and I have seen hundreds. He was truly spectacular, and so obviously so that immediately afterwards, those on his own team who had strongly opposed Milky's presenting the argument readily admitted they were now eating crow pie, end quote. That is truly high praise given the quality of the advocates who appear before the Supreme Court, and having now had the opportunity to work with Justice Milky, I can't say that I'm surprised. Now, because I had known about Justice Milky's reputation as a brilliant attorney, I admit I was a little intimidated by him when I first joined the court. And there's a second reason, which is that I had argued before Justice Milky after he became a judge. 4 times, as a matter of fact. I looked it up last night. He has no recollection of this, I'm sure. Don't worry, you were nice. But after spending so many years on one side of the podium, it was surreal, to say the least, to suddenly be sitting on the other side of the podium next to someone who I always thought of as somewhat larger than life. So lo and behold, in just my second month on the court, I was scheduled to sit with Justice Milky, along with my judicial mentor, Gabrielle Wolohojian. This made me apprehensive for a third reason, which is that I had heard that Justice Milky could be something of a, shall we say, tough reviewer. That might be a little bit of a euphemism. This was confirmed by Justice Wolohojian when I sent one of my drafts to her to review in her role as my judicial mentor, and she came back to me and said something to the effect of, "I'm not sure about this one part of the draft, but go ahead and send it to Jim and see what he thinks. He has an opinion about everything." This is true. But not only did I survive sitting that first month with Justice Milky, I began to look forward to the months when we would sit together, because I came to appreciate that, yes, he does have a lot of opinions, and he's not afraid to express them, but that is born from his deep commitment to getting it right and improving the work product of the court. The appeals court has a process called second panel, in which all published opinions are first circulated to the full court for review and comment. In his 15-plus years on the court, Justice Milky has reviewed and commented on every second panel opinion that was circulated, other than cases in which he was recused. By my math, that is over 2,000 opinions. And I know I speak for many when I say that I truly valued and appreciated the time that Justice Milky spent reviewing my opinions and providing constructive feedback. His comments always added value, and his departure will leave a huge void in that respect. Simply put, he made our work better. Justice Milky himself is a brilliant writer and a prolific one. If my research is correct, he has authored over 160 published opinions, including approximately 30 separate opinions, meaning dissents or concurrences. Does that sound right? Okay. Justice Milky's commitment to getting it right often required him to take positions that might be unpopular, such as standing up for the most vilified members of our society or calling out governmental officials for misuse of their powers. He's never been afraid to do so, and his opinions reflect that he never lost sight of the real people whose lives are affected by our work. Justice Milky is also an exceptionally skilled jurist. Part of what makes his opinion so powerful is that he is able to see and grasp the nuances of a case which might have escaped someone else and present them with his characteristic mastery of words. Not only that, he is faster than the speed of light. He is incredibly efficient, and yet every one of his opinions is a model of eloquence and clarity written in a way that ordinary citizens can understand. Justice Milky's contributions to the law of this Commonwealth are immense and sure to be enduring. On a more personal note, I will very much miss Justice Milky's wit and quirky sense of humor. He can carry on conversations on a wide variety of topics, from sports to movies and television to Beethoven, and he is always quick to laugh, including at himself, an admirable and underrated character trait. The lunchroom is always more entertaining when he is there. As one of our colleagues, who it's fair to say is not ideologically aligned with Justice Milky, as he recently said, "We rarely agree, but it's hard not to like the guy." Jim, it's been my privilege to be your colleague and to have learned from you during our time together on the court. Congratulations on your 40 truly exceptional years in public service, and I wish you and Kathy all the best in your retirement. Your departure is a huge loss for us, and we will miss you. This place will be a lot less colorful without you here. Justice Englander.
Good morning, everyone. It's an honor to sit with Judge Milky during his final sitting on this court, and to add a few words about what a pleasure it's been to work with Jim these past several years. Now, I'm tempted to say that Judge Shin has said it all. There's going to be some overlap. We did coordinate a bit, but we use the same words, and maybe that's a testament to the personality that Jim has projected for us over these years. If you've ever sat with or worked with Judge Milky or faced him, as Judge Shin did, from the other side of the podium, it's readily evident Jim is a very smart guy. He has a remarkably active and curious mind. He's not satisfied with a superficial answer. He digs deeply into the briefs and the case law. I learned all this very early because I came on 7 years ago, and Jim was very quickly explaining to me things that I'd missed. I think I sat with you my second month, actually. Over the years, I've been amazed, as Judge Shin indicated, at Jim's energy and at his efficiency. Jim seems to fire off a thoughtful draft or an email with 6 numbered points to chew on before I've even had time to consider the subject matter that he's addressing. As Judge Shin mentioned, Jim is just about always the first to respond to a draft opinion circulated to the entire court, what we call second panel, and Jim's responses always have an interesting take on the case, frequently a take that is additive or new, not previously considered by the panel. Although I will admit that sometimes Judge Milky's comments come back so quickly and with such exposition that I think, jeepers, can you just give us a break? Give us time to catch up? And I'm kidding, of course. I joke because Judge Shin already noted Jim has an excellent sense of humor. Inevitably, there are contentious moments on our court, and Jim is a very good-natured colleague, even when the barbs are directed at him. As our former colleague, the fabulous Sidney Hanlon, used to say admiringly, Jim can take a punch. But of course, Jim can give as good as he gets. Just a few weeks ago, I circulated an opinion to second panel, and Jim, as usual, was the first to respond with his characteristic acuity. He wrote, "There seems to be a problem with the PDF version. Blank pages. Alternatively, it's the best thing you've ever written." But what I most appreciate about Jim, what I think we will all miss, are 2 traits that characterize Jim's approach on the bench. And Judge Shin has already mentioned these, but I'm going to say them again. The first is that Jim very much cares about getting it right. His energy is directed to understanding the case, the applicable law, fully. He brought this energy to every case, but particularly to the notoriously complex areas of land use and environmental law, areas of common interest for the 2 of us, but as to which Jim is a true expert. I don't know that Jim has yet forgiven me because in that early sitting, I drew the case about tidelands called Maslow versus O'Connor, and he thinks I should have just turned it over to him, but I kind of liked it, so I took it myself. The second trait Judge Shin has already mentioned, but I will describe as judicial courage. Decide cases on principle, not on what observers or the papers might say, and Jim has done that. He's been willing to take the unpopular position and thoughtfully to explain why. Jim's favorite opinions are those that he wrote alone, in dissent or concurrence, saying what he thought needed to be said. And as a result, our understanding of whatever subject Jim chose to exposit on was enhanced. Whether it was, for example, the practicalities of a stop for Article 14 purposes or the meaning of the word lewd. Jim, it has been an absolute pleasure.
Thank you very much. Now, in the appeals court, we do not allow time for rebuttal argument. So I will not try to rebut those kind words, but I thank my colleagues very much and thank all of you for coming, at least you who don't have to be here for this sitting. It's important that now we clear all the riffraff out of the court and return to the business of the people who are required to be here. So if anyone wants to leave, this is a good time to do so, and we will continue in about 2 minutes' time.
All rise, please.
No, we're going to stay. Thank you. Okay, thank you all very much. Just preliminarily, I want to assure the parties we have read the briefs. We have gone to the record and examined the relevant documents. So I mention this because 15 minutes is generally not a great deal of time. So we urge you to cut to the chase to the extent possible. And to the extent you don't, we'll be very happy to help you with our questions. If, on the other hand, you feel like you have said everything you have to say, there's no shame in sitting down. As our former colleague Joe Grasso was fond of saying, if you hit a home run, there's no reason to run the bases twice. So with that said, we're going to call the first case. It is Commonwealth versus JAIME Hill, 2023 P1076. Counsel?
Good morning, Kara Chayette for the defendant JAIME Hill, and it's an honor to be here for your final sitting, Justice Milky. I'm going to start with the instructional error on wanton and reckless battery. I do want to make a couple of points about Creighton, but I can't leave the podium. I have a specific request I actually want to make of the court with respect to the duplicative conviction, so I'm going to be watching for my 2-minute mark. Wanton and reckless battery. I'm not making a sufficiency argument. You don't get there because the jury shouldn't have been misled into thinking that reckless battery was a lawful avenue of conviction. Reckless battery requires serious bodily injury.
How is that different than a sufficiency argument, though?
I'm sorry?
How is that different than a sufficiency argument? You're just saying there was insufficient evidence for the particular crime to be presented to the jury, right?
No, you know, the best analogy I could think of was in the civil context, like the difference between a motion to dismiss and a Rule 56, right? If there's not even a well-pleaded allegation, you don't get to the fact finder. And as, you know, the Plunkett said, you don't, it's to give the jury an instruction for which the prosecutor has disclaimed the existence of critical evidence, the complainant has disclaimed evidence of a critical, it's like a trick question. You give the jury a ring of keys and say
the prosecutor didn't disclaim the existence of the evidence.
Oh, no, in his
prior to the time it was submitted to the jury.
No, I'm sorry, Justice Englander, in his opening, the prosecutor said, thank goodness Mr. Morgan wasn't injured, more so he was shocked, surprised. And then the entire case goes in as this intentional crime, which is why, you know, I was thinking about why wasn't there an objection to the reckless instruction. The way this happened when
I'm reminded of an opinion that I wrote this morning, written by Justice Scalia in Griffin, where he said the distinction that you're trying to draw, he was struggling to see how that distinction added anything, that's all.
But your point, I take it, is that this was instructional error. The judge never should have instructed the jury that they could have found him guilty based on reckless battery.
That's right, because you have to have serious bodily injury for that. And just
What is our analysis on appeal? Isn't it the same that we have to decide whether we need to determine whether the evidence is sufficient on both theories, including the one on which the judge shouldn't have instructed?
No, because I think the Commonwealth benefits from, evidence in the light favorable to it if you're in sufficiency. I think that this is a very different analysis, and I'd point you to Azar, which I cited in my brief, but in that case, there were 4 errors the SJC said equaled a substantial risk of a miscarriage of justice. And they line up not perfectly, but in some ways better for me and different. So in Azar, the judge misstated the law on a critical element. There was insufficient evidence if the jury had been correctly instructed. The prosecutor invited conviction on the misstatement of the law, and there could be no tactical reason for the failure to object. Here, we have a correct statement of the instruction, but it should never have gotten to the jury. And the prosecutor invited the jury to mix and match elements, take a fact and apply it to this element, take a fact and apply it to that element of the other theory. And there's absolutely no reason to think that this was a tactical failure to object. In fact, the defendant was really prejudiced. When I was going back through the transcript, I realized that the charge conference happened right after the Commonwealth's case closed. So there's a motion for required finding on the intent issue, which is what was at issue in the Commonwealth's case.
Seems it was backwards.
Right, well, but so it ended up being, I understood better what happened here. So then defense puts on its affirmative case with Mr. Hill on the stand. And then after the close of all the evidence, then there's a little discussion of some argument about instructions. And just as they're recessing for lunch, the judge says, intentional and wanton and reckless, and the prosecutor says yes. It happened so quickly and so oddly, it actually occurred to me that it might have missed defense counsel's notice. He comes back. He, of course, goes first, gives his closing, all about the missing intent requirement. And then the prosecutor gets up and says, oh, no, we don't have to prove injury. You can take a little bit of this, a little bit of that. It was an outrageous closing that really crossed the line. And if
Part of my confusion, though, counsel, is what am I missing here? Isn't this just a straightforward application of Plunkett?
Well, but Plunkett says if there's no reason to think that, in fact, I mean, there's that little bit of language, if there's some conceivable sliver of possibility that they credited the other theory, then maybe. But Plunkett says if you're going to mislead the jury, they're going to think, well, there must be evidence to meet the elements.
I think maybe I misread the case. I thought Plunkett said, we reject Griffin. If you've got 2 theories that you present to a criminal jury and you get a general verdict and one of the theories is bad, the verdict can't stand.
Oh, no, that's misread. So that's misread. Plunkett says if it shouldn't go to the jury, there's a general rule that if there's not any evidence, zero, zilch, then you've got a problem. And here,
But we still have to decide whether they're distinct theories, right? I guess I'm confused because let's say a judge instructs on all 3 definitions of serious bodily injury. Right? Commonwealth versus ANOA says those are not distinct theories. So let's say even if there's absolutely no evidence to support one of the definitions, how does that change our analysis on appeal?
Well, and part of it is this cumulative piece of you've got this wrong theory going to the jury. You've got the prosecutor saying, hey, select from here, select from there, and combine
I understand the closing argument is separate, but putting that aside.
Well, but I do think if I could just say the third piece of that is that what the prosecutor argued in his closing wasn't just that mix and match hybrid theory, but he actually benefited from the inference that the defendant wanted to make the argument that it was an accident. The prosecutor says, he argues that Mr. Hill threw the keys into the car, hit the dash or window, and they ricocheted off and touched Mr. Morgan. If you are committing an intentional, lawful, even if it's negligent or reckless act that results in an unintended, non-injurious, accidental touching, that's an accident, that's an acquittal. And what the prosecutor argued is because you're going to get that wanton and reckless instruction, you can do that. So it's a combination of sort of how the DA, trial DA, argued the law and what inferences he argued the jury could draw, all of which inured to the defendant's tremendous detriment, where he sought twice an accident instruction and the judge denied it twice. And so I think that trying to just pull out this question of the instructional error, if that's all it was, that went back, maybe this is a different case. But this is actually a series of wrongs that were done. I appreciate that you're struggling with it, and I also understand that there's something a little
I'm still on the
subtle.
same point. I mean, we reject the Commonwealth's argument that we should abandon our established rule that there must be evidence to support each alternative theory submitted to the jury. That's Plunkett. That's this case, right? Isn't it just a straightforward application? There must be evidence to support each alternative theory. Here, there's not. There's no evidence as to bodily harm. Recklessness fails. Therefore, under Plunkett, the case goes away.
No, so I would point
What
you
am
to...
I missing?
So I was looking at Poro, because I didn't know whether I needed to anticipate the question whether wanton and reckless was somehow lesser included, and I started drilling into Poro.
There's an additional
But-
element. There must be substantial bodily injury. That is not present in the other way of proving assault and battery, right?
Yeah, but so
Okay, so if there's an additional element, how can it not be a different theory?
in Poro, the court discusses, it's in the context of lesser included. Poro's the guy's driving, he swerves a couple times, hit the motorcyclist, and the motorcyclist goes flying and has serious bodily injury. The Poro's cited in the Commonwealth's brief, but not for this point. And so the SJC says a couple things. It says the question in that case was, is assault under a theory of threatened or attempted battery a lesser included of an intentional assault and battery? And so what the court says, yes, but on remand, the jury may not be instructed on an attempted battery because the evidence disclaims an attempt. You don't get attempted battery instruction if you have a successful battery. And the court also discussed Thayer, in which you've got a greater and a lesser included crime. And the court said in the lesser included, there are sometimes, it's uncommon, but it happens where the lesser included has an element that the greater doesn't include. The jury doesn't get that instruction. You don't give it to them. So it is an error. And then when you're sort of questioning, well, certainly there was prejudice. I think the standard is substantial risk, maybe, but it's certainly prejudicial given this sort of cavalcade of other problems, a lot of which flowed from the closing argument that was admittedly unobjected to. I wish trial counsel had jumped up hair on fire.
What is your strongest case for, on the prejudice issue, where the prosecutor plainly misstated what the law was, but the judge otherwise properly instructed the jury? You argue that the judge shouldn't have instructed on the reckless theory, but putting that aside for the moment, the instructions the judge gave as to the two theories was accurate. And albeit the judge didn't give a curative instruction in the sense of calling the jury's attention to the prosecutor's error. Under those circumstances, where there is no objection by counsel, do you have a case where an appellate court found a substantial risk?
Well, so Azar, I think, has that sort of, you can walk through that.
Wasn't I may be forgetting Azar, but I thought there was actually a instructional error there.
So it was a misstatement of the law. The prosecutor invited conviction on the misstated law no objection. And so
Except the misstatement there was by the judge.
that's right, that's right. But I do think that Plunkett, actually, there's language, and I quoted it in my reply brief, that the jury can be misled into thinking, well, the judge gave us this instruction, there must be some evidence. You know, you can, I mean, that's the thing. It's like my ring of keys analogy. You know, I'm giving you a ring of keys. One is the good one. The rest are blanks. You go back in the jury room and you figure out which one opens the lock. It's not supposed to be a trick question. If they're given the instruction, and that's what, there's language in Plunkett, and I appreciate Justice Englander, that there might be some other part of Plunkett, but that's the worry that the Plunkett court identified.
So Azar was a case where it was the instruction that gave rise to a substantial risk, right?
No, it was the four. The court said it's the four things. It's the misstatement of the law, the lack of evidence to support that, the
Right,
prosecutors.
but the underlying claim was challenge was to the instruction, not a closing argument, right?
I think you're
Do you
right.
have a case about it that finds a substantial risk based on a closing argument?
Just based on closing argument, I don't know if I know I had a parenthetical about the closing. I'm not sure if I can go further than that. And I see my time is running down. I don't want to not answer any further questions on this issue. There were a couple points that I wanted to make on Creighton just to really emphasize 15 minutes masked.
No, your argument on how there was error regarding Creighton is easy to understand. How about prejudice, though?
On the Creighton?
Why wasn't this similar to someone robbing a bank who has to show ID and sign his name before he passes the stick-up note?
Well, so two things. You know, the Morgan says his checking of that whoever is getting into the car is a confirmatory one. It's like you go to the ER, there's this whole big blown ID thing, and then you go into the room with the radiologist and it's this confirmatory, are you the guy that I'm taking the x-ray of the knee? So, and he's not a cop, that's not his specialty, and he churns through thousands of people. The fact that he might be able to say, the photograph looks like the person is different than saying that the perpetrator, I can identify the perpetrator. And I have case law in my brief about that. But to say that 15 minutes, oh, go ahead.
I'm afraid your time is up, but you wanted to address the probation sentence.
I did, and just on the Creighton, I'd point the court to the lowest bar that the Commonwealth argued for at page 6 of the motion transcript, and I'll leave that at there. So the Commonwealth acknowledges that the convictions in this case are unlawfully duplicative. My guy was slammed on his sentence. He got 1 year committed on one conviction, 1 year followed on probation on the second. He's currently serving an unlawful sentence of probation. So I'd ask, the court's going to take whatever time it needs to decide the case, but I'd ask for an immediate and limited remand to the district court to stay execution of the balance of his probationary term while you decide the case, and to consider addressing in your decision how frequently this happens, and that this should be, especially in district court where there's no right to appeal to the appellate division, that it's everyone's obligation to take care of this at trial. This shouldn't wait for an appellate appeal to go all of its lifespan and to wait for an appellate DA.
I think we understand the point.
Thank you very much.
But he is currently...
He wrapped his committed sentence in late December, January, so he's right now under the shadow of that probationary term.
Thank you very much, counsel.
so much.
We'll hear from the Commonwealth.
Good morning. May it please the court. Travis Lynch for the Commonwealth. Perhaps I'll start with the Creighton issue.
Actually, if you don't mind, can you answer the question I asked your colleague?
Sure.
Why isn't this case just controlled by Plunkett?
It's not Plunkett because, and this in part answers your, Justice Shin's question, because the distinction between different types of battery is not a theory in the way that...
The case you rely on for why they're not different theories is what?
Mistretta, which then relies...
Mistretta isn't about theories, it's not about Plunkett. Mistretta is about whether or not there needed to be specific unanimity instruction, and it's a rescript where it's very hard to figure out exactly what we're saying, to be honest. Other than Mistretta, you got anything else that tells me that these are not within the scope of Plunkett because they're not two different theories?
Well, I would say that if you...
I mean, I understand your argument about, I don't mean to totally dismiss Mistretta, and I don't mean to come on too hard, but I'm really struggling with this. How can they not be two different theories when there's an additional element for reckless battery?
They're related ways of committing the crime. If you think about, it's canvassed in the brief, but if you look back at Plunkett itself, I believe it's the difference between different theories of first-degree murder. And
it is?
Yes.
Correct.
And I believe it's deliberate premeditation and felony murder.
Correct.
Pre-Brown felony murder.
Yeah.
Those are...
No question, those are different theories.
Those
Why
are-
aren't these, though? I've got a different element. And in fact, it's the element, as your sister points out, it's the element that the prosecutor said, I don't have to prove.
Well, he is right about intentional battery, that's for sure. But if you look at the Santos case by the SJC, which is cited in my brief at page, there's a discussion of, or it seems as though in the Santos case, 440 Mass 281, that when the SJC says different theories, it seems as though it's limited to different theories of first-degree murder and different ways of committing manslaughter, the distinction between voluntary and involuntary.
Why would the principle be limited in that way? I've never, well, I shouldn't say I've never because I'll be proven wrong, but as I sit here, I can't tell you that I've seen another principle that says we're only going to apply this general principle of law to murder cases and not others, right? I mean, it's written as a general principle, which is if I just read the quote.
It does seem, and
Established rule, there must be evidence to support each alternative theory submitted to the jury to uphold a general verdict.
Right.
That's not of murder. The words of murder aren't in there.
But it seems as though the court has only applied it to different theories of first degree and different theories of manslaughter.
But
There's a variety-
counsel, you're talking about the situation where on appeal, the argument is the evidence was insufficient on one theory and therefore it has to go back in any event. That's not what the argument is here. The principal argument is the prosecutor misstated what the law was in a rather material way, saying, I have to prove neither intentionality nor harm. And that itself seems like a pretty big problem, and the question is, was it cured by otherwise proper instructions? And in terms of whether or not there was instructional error here, had counsel been on the ball and said, Your Honor, in your instructions, I don't want you instructing on a reckless theory because the Commonwealth can't prevail on that theory. So I want you to instruct only that it was intentional battery and let me argue that it wasn't intentional. Wouldn't the judge have been obligated to abide by that request, regardless of how Plunkett applies?
Sure. I think you're right. Yes, I mean, quite frankly, it would have been better if a reckless instruction had not been given in this case. But giving the instruction does not require a new trial because it's not really a different theory in the way that Plunkett is talking about different theories. I mean, in Anoa, for example, which I believe was Justice Shin's case, I believe the jury were instructed on the different types of serious bodily injury, even though there wasn't evidence of all of the types of serious bodily injury. And that's, the court in Anoa did not separately analyze the evidence. I believe there was a claim of instructional error in that case as well. So to your point about what effect the prosecutor's admitted error in closing on this point is, I would say that because the judge, first of all, no objection to any of this, no objection to the instructions other than with respect to the request for an accident instruction. The judge told the jury, the judge defines what the law is.
Normally we would say no substantial risk because the judge gave a correct instruction, we presume the jury followed the correct instruction. Right. But here you're dealing with an instruction that really shouldn't have been given at all, right?
Yes.
There's no evidence of any substantial injury. So how can we say an instruction that shouldn't have been given at all cures what was a pretty egregious argument in my view?
I'd say that our primary argument below was that this was an intentional battery. That's one response to that argument, or that question.
Even though the opening of the prosecutor's closing argument was, we don't have to prove intentionality.
I think I would say that he asked the jury to credit Mr. Morgan's testimony. And on Mr. Morgan's testimony, this is an intentional battery. That's our primary point here, or that's the Commonwealth's primary argument below, I would say. And again, none of this is objected to. The closing's not objected to. The judge tells the jury, it's my job as the judge to tell you what the law is. The closings aren't evidence. I'd also point out, the jury was not swept away. They didn't find that the keys were dangerous as used, which I would submit is another reason why there's no substantial risk of a miscarriage of justice here. And in any event, the injury instruction in the reckless battery instructions for every time it was repeated, they were told, they were properly instructed what injury was. And I'd also point out, they were told what injury does not consist of.
But why did that go to the jury at all? I know the answer is because the defendant didn't object.
Correct.
Putting that aside, it shouldn't have gone to the jury, right?
Right, it shouldn't have. But it doesn't mean that we need to order a new trial in this case.
Well, maybe if nothing was done with it, but when the prosecutor opens with the opening paragraph of his, hey, we don't have to prove intent because there's a recklessness theory, he kind of puts it front and center, right? And then he doesn't mention the fact that, oh, by the way, I can't prove that crime because I admit that there was no bodily injury. It strikes me as, at least as your sister says, in combination, pretty problematic, right?
Maybe if this was prejudicial error, perhaps. But again, it's substantial risk. But your point is well taken.
So that goes back to Judge Shin's question about whether or not there are any cases that find substantial risk out of a prosecutor's closing argument, particularly where the jury's properly instructed that that's not evidence, right?
Right. So, again, our primary position with respect to the claim of instructional error is that these aren't separate theories for purposes of the Plunkett rule, and therefore the instruction.
And the best case you have for that is Santos?
Well, I'd say it's Mistretta because it's
Mistretta.
Right.
But both Mistretta and Santos, as I read them, are about specific unanimity instructions, which you equate in your brief to the question of whether they're different theories, right? So I've got to parse my way through that to figure it out. Okay.
With respect to, there was one other question about instructions. No accident instruction as requested by the defendant was strictly speaking necessary here because I would say even in the light most favorable to the defendant, accident's not fairly raised. The defendant's testimony is he threw the keys in the car and then the victim started yelling, and then Mr. Morgan started shouting. And he testified also he saw where the keys landed and he didn't hit Morgan at all. I would submit that the defendant's argument is the defendant's evidence actually established, if you credited it, they didn't hit Morgan with the keys at all. So No accident.
But the prosecutor came up with a theory in the closing that they bounced off the dash.
Yes, I understand your point. But again, we're talking about whether an accident instruction, also, if you look at the battery instructions, it says it has to be intentional and not an accident. So cases like Maloney, which are cited in my brief, would say the jury know that they have to find that the conduct was intentional in order to convict the defendant.
So if the jury had been instructed that in order to convict the defendant, they would have had to find intentionality here, that he intended to hit the instructor with the keys. Isn't that a very different case going to the jury where there are two different versions of what happened?
Than what was actually submitted to. I think that what the defendant's argument below really was, I didn't hit him with the keys.
You have 3 minutes left.
Yes.
Do you want to address the...
On the Creighton issue, the witness interacted with the defendant for several minutes before the crime happened. This is not a case in which the only time the witness had to interact with the defendant was when the defendant was committing the crime. I think the best
But isn't this very different from Fielding, a case I know something about?
I know that you know about it.
Where the victim and the defendant were in the hot tub together between that and the sauna for a half hour, talking to each other. This is a business interaction inside a car where the defendant has a mask on, and the instructor is, I hope, got his eyes mostly on the road to see how the guy is driving. Why isn't...
Well, I think the best fact for us is the identification card with the defendant's picture and name on it.
I'm sorry, I didn't hear that.
The identification card, the learner's permit, which had a photo of the defendant. So it's not
No,
just...
that may be how the Commonwealth could have proved identity had they lost the Creighton issue. That seems very different from getting over the hurdle that he can identify him in court based on that very brief interaction in the car.
There's no bright line rule in Creighton. There's no bright line rule. It's an abuse of discretion standard. And again, he had a picture of the defendant, the defendant's picture ID, and he interacted with him. I'd submit that's enough. It's not outside the reasonable range of alternative.
That 2 years later, he can say, that's the guy, pointing to my wife.
I understand your point, Justice Milky, but again, he looked at his picture.
Your sister says it is a bright line rule, and if you read Creighton, if you read Creighton, it's establishing a rule that says you can't be looking at whether there's indicia of reliability. And your argument is that there are indicia of reliability because he had 15 minutes with the guy before the keys got thrown. What do you say to that?
I would say that the examples that are in Creighton are merely examples of when there's good cause or good reason to dispense with an out-of-court identification procedure.
It seems to me that that Creighton blurs this whole line because Creighton says, well, one example of good cause is that you know the person.
Right.
And the limits of what knowing the person are
not spelled out in the opinion.
And very difficult to have a bright line rule for, it seems to me.
I agree. I don't think there is a bright line rule.
Just housekeeping matter,
Sure.
do you have any objection to the stay issue raised by
No.
the defendant?
No objection to that.
We'll have to leave it there. Thank you very much.
Thank you.
That case is submitted. Our next case is Commonwealth versus Jason Woods, 2022 P 427.
Good morning, Your Honors. May it please the Court. Deborah Bates Reardon representing Mr. Woods. The first issue is that he was convicted of possession of ammunition without an FID card and possession of a loaded firearm without a license. In this case, because the only ammunition that was found was inside the gun and inside the magazine, and it could not be seen by the naked eye, possession of ammunition without an FID card is a lesser included offense of the possession of the loaded firearm. And as such, it's a violation of the Fifth Amendment, his Fifth Amendment right to be free of double jeopardy, to be convicted of both crimes. So he was convicted on both crimes. And as such, the lesser included offense should be vacated. My next argument is the motion for...
Was he sentenced on the lesser included offense?
I'm sorry, sir?
Was he sentenced on the lesser included offense?
He was sentenced to concurrent probation on both. They were from and after the he was sentenced to...
But we don't have the same problem that we had with the case just before you, which is, if you're right, he's serving a probation solely on that theory, right? Here, it's a concurrent with another criminal conviction.
Yes.
Okay.
The same theory serves to find...
Understood.
To
Okay.
meet the needs of both. So
Could we cut right to the knowledge of the loaded firearm issue?
Sure.
Because that seems to be where the rubber hits the road.
Yes, well, unfortunately, there were 3 guns that were found among the 11 people that were standing there. One was at open viewing on the sidewalk near the park. The second one was inside a takeout container that was closed. And the third was found in Mr. Woods' inside jacket pocket.
Well, I mean, the Commonwealth's argument is simple, that if you've got a gun inside the pocket of your jacket, you probably know whether it's loaded or not. How do you respond?
But without more, that's not enough to satisfy the knowledge requirement. To contrast, in Resende, the defendant was found with the firearm tucked in his waistband. It was late at night in an area, a crime-ridden area of town. He was by himself, and shortly before the police arrived, he threatened someone and referred to a weapon, to a firearm.
Well, with the exception of that last piece, well, I guess he's not by himself, but he's with 11 people, 2 of whom are armed, besides himself, right? And it's late at night, and he's got the thing on the inside pocket of his jacket.
That's true.
No inference can be drawn that he knows that it's loaded.
I don't feel that it's a fair inference, because there were other people there, and it was not some,
Other people who are armed.
But we don't know who those guns belong to either.
Well, one of the critical facts I see here is that there was a round in the chamber.
It was a round in the chamber, yes.
Somebody, in order to put the round in the chamber, had to rack the slide to put it in there. Why isn't it reasonable to infer it's the person who was carrying the gun?
There's no evidence as to who brought the gun.
I understand, but we're talking about reasonable inferences. It's found in his pocket. It's very accessible to him, and there's a round in the chamber. So one of the officers testified it was ready to use. So why couldn't a jury reasonably infer that he's the one who put the bullets into the gun?
Well, in the context of this situation, the police arrived and they find liquor and beer containers spilling out onto the park, onto the ground, and they find the two other firearms. One was hidden in a takeout container, and the other one was just abandoned quickly. So things happened very hastily.
But doesn't what Judge Shin points out distinguish this case from, there is a case, I don't have the name in front of me right now, but you rely on it. It's the closest case for you, the best support for you. It's the guy who has, the gun in his waistband, right? And we say it's not enough. But that gun, as I recall, was one, wrapped in a sock, so it's not readily available, as this gun was. And second, I don't think there was a chamber. I don't think there was a bullet in the chamber already.
I think that was the
Grayson, I
case
think,
that
is
you're
the name of the
referring to.
case, right?
Pardon me?
Grayson.
Yes, Grayson.
That's your best case, right?
That is my best case.
Doesn't Judge Shin's point about the round being chambered distinguish Grayson?
I'm not sure, I can't speak to whether there was a round in the Grayson gun or not. I don't know that off the top of my head. But in Grayson, they said even though the gun was tucked even closer to the defendant's body, that it wasn't enough to prove that knowledge.
But it was in a sock.
It was
So one
inside
can
a sock.
imagine a scenario where somebody handed him the gun in the sock and he didn't know if it was loaded. This seems where you have a not only loaded but chambered round, and it's in the pocket of his jacket. Why isn't that enough to get that issue to the jury? It's not who wins, but is it enough to get it to the jury?
I don't believe that it is. I feel it's close enough to Grayson that it should be decided the same way that Grayson was. Because there's no evidence when it was put in his pocket, or if someone gave it to him. They were abandoning everything that they had, the liquor, the guns. People
And
were-
that's true,
it was
that's
a hasty-
possible, but that argument falls under our, the standard language, which says that we don't, on sufficiency review, we don't take into account all the other ways that he might not have been not guilty. We take the evidence in the light most favorable to the Commonwealth.
That is true. That is true. I made that same argument for the possession of the ammunition. That he did not, they did not have enough evidence to prove that he knew there was ammunition in the gun. And I made the same argument, so I won't repeat it to you.
Understood.
And the alternative argument is that, given the Guardado cases that came forth and the Bruin case, the Supreme Court case, this case was tried and he was convicted before Bruin, saying that there was which now says it's a requirement as an essential element of each crime that the Commonwealth prove that the person was not licensed. And because it happened, this case happened before Bruin, they didn't have the crystal ball to know, if you will.
Did you make this argument in your brief?
I filed a supplemental brief,
Okay.
which was accepted by the court. And I made it in that argument.
So just to be clear, this case was tried pre-Bruin?
Correct. So the Commonwealth at that time didn't know it was going to be a requirement. It was not. It was an affirmative defense. Now the case has changed. The requirements change. The Commonwealth has to prove it beyond a reasonable doubt. It's an element of the crime. In the alternative, I would argue that the conviction should be vacated and the case should be remanded to the trial court. And if there are no other questions, I'll stand
Thank you
my
very
case.
much, counsel. We will hear from the
you.
Commonwealth.
Good morning, Your Honor. May it please the Court. Ian McLean on behalf of the Commonwealth. Your Honor, very quickly, the duplicative question is not, essentially it's rendered moot by the Guardado issue. If we were asking you to affirm both, then it would be a problem, but we're not asking you to affirm both. We're acknowledging the effect of Bruin, as this case was still on direct appeal when Bruin was decided, so the case has to get remanded. So the duplicative conviction of the ammunition and the loaded is simply not
So
before
the case
you.
has to be remanded, and the Commonwealth concedes that
Yes, Your Honor.
on all convictions?
Yes, Your Honor.
Okay.
So really the only question then is, are we permitted to retry on all three counts, the sufficiency of the evidence? The only of the three charges that they challenged was the loaded, and the crux of the issue is whether the defendant had knowledge that the firearm was loaded. Your Honor, I'd point you to Milky, or excuse me, Justice Milky, I'd point you to Ralph R. as the principal case to take a look at. That comes after Ralph R., Your Honor. That comes after Resende and Grayson, and there the SJC sort of clarified that where the weapon is placed and its ability to be immediately used can be that plus factor that they're talking about.
What's the site?
For Ralph R., Your Honor?
Yeah.
100, oh, I apologize, Your Honor, it is a case out of this court, but it is in 2021, so it did come after Resende and Grayson, but it's 100 appeals court at 164.
So you think that modifies Grayson?
I wouldn't say modifies, Your Honor. I'd say it acknowledges that sort of that plus factor that this court has spoke about in both Grayson and Resende can be satisfied by where the weapon being placed for immediate use. In Ralph R., it was in a sweatshirt pocket, a loaded firearm ready to be immediately used in an easily accessible pocket. That makes the case categorically different than, say, a gun that's in a backpack or a bag or something where it's not available for immediate use. So in addition to it being against the body, it's also available for immediate use. That's our principal plus factor here. But we have the additional plus factors that I would say go along with the fact that when this weapon was discovered, the defendant was in a group of other young men, and there were two other weapons also there discovered. So the inference there being access to, familiarity with firearms. Also, again, it contributes even further to the need for immediate use. We now have a defendant who's brought a loaded weapon with a chambered round to a public park late at night where alcohol is being consumed, and there are other firearms in that same environment. All of those things, along with his placement of the weapon in an interior pocket of his jacket for easy access and immediate use, all of those things strengthen that inference that he wouldn't have put the gun in that location without first checking it to confirm that it was loaded. So if there are...
And you think, so how do you distinguish Grayson? Leave aside Ralph R. I apologize, but our green books back here go to 99. How do you distinguish Grayson?
Your Honor, Grayson, the firearm was in a sock that was tied at the top, so that point alone made it harder to infer that this particular defendant had checked the weapon himself. Could have merely been handed to him with the tied sock at the top. That's the largest distinguishing factor or characteristic here. This case is more in line with Resende, where it was in the waistband, or Ralph R., where it was in a sweatshirt pocket. And because the access to the weapon is not controlled by something, the inference is stronger that
Resende has the additional fact that the guy mentioned a gun and threatened. Were there similar additional facts in Ralph R.?
Not the threat and not the mention of the gun, Your Honor, no. So Ralph R. is simply a loaded firearm that was in the sweatshirt pocket. And that's why I think...
No other facts, just that.
There was also flight from the officers, but those are the only facts in Ralph R. And that's why that's the most important case, because it comes after in time from Resende, Grayson, Cooper, all of the other cases that talk about the need for the plus factor. If you look at Ralph R., the plus factor is found from where the defendant located the weapon such that it was available for immediate use, the easy access to the weapon. And again, that's also another factor that takes us out of the realm of the car console cases, Brown, Ashford, Galzara, those are all cases where the firearm is stored in a place that doesn't have immediate access for immediate use. So this case categorically different from that line of cases. Because we have it stored in a location on his person where he would be able to access it immediately for use. When also combined with the fact that there were other firearms amongst this group of young men in the park that night, and alcohol being consumed as well. All of those things strengthen the inference that he would have checked this weapon to confirm that it was loaded or not.
So you don't rely on the round in the chamber. Do you think that's relevant?
Yeah, absolutely, Your Honor. Absolutely, it's relevant. It does factor into whether someone checked to see if the weapon is loaded. As was argued below by the trial prosecutor when the motion for required finding was raised. Trying to give Justice Englander a moment to see if he wants to get to a point in Ralph R. to discuss it or not.
Aside from that, is there anything else you have?
No, there's nothing else that I'd like to add as long as Justice Englander doesn't have any questions as a result of Ralph R.
Thank you, counsel. I appreciate your patience, but I don't. Thanks.
If Justice Englander has no further questions.
Thank you very much. The case is submitted.
Thank you, Your Honor, and I'd just like to say on behalf of not just myself but my entire office, while we haven't always agreed, it's always been an honor.
Thank you very much, counsel. Our next case is 2022 P635, Commonwealth versus Matos.
All right. Good morning. May it please the court. Matthew Zandrowski on behalf of Luis Matos. So I'm going to focus on the stop to start my argument here. And so leading up to the stop, we have the detective made some observations of a passenger inside of this 7-Eleven. And he said, the only observation we have of this passenger is that it looked like he was leaning over the counter. And then from that, somehow the detective drew that, well, it looked like they were leaning over to take money out of the register or maybe to point to something that they wanted. He wasn't sure.
But doesn't the context matter here? This was, the officers were out there investigating 7-Elevens getting, to use a colloquial expression, knocked off. And in that context, he sees somebody leaning over the counter.
Right. Well, I think that we don't have any specific information that this 7-Eleven had been robbed. We don't really know which ones had been robbed. And I think that it's still entirely consistent with someone legally shopping at 7-Eleven. The 7-Eleven was open for business. And so leaning over the counter to, even as the detective had to concede, to point out something that they wanted, he wasn't sure. There's no other context there. There's nothing in his hands. There's no, I think in this case, importantly, there's no alarm, there's no 911 call, there's really nothing else to support that this was a robbery or anything nefarious other than someone shopping at a 7-Eleven that's open late at night.
Just curious, what else do you think he might have been doing, reaching over the counter?
Well, you know, the judge didn't credit it, but the defendant's affidavit said he was pointing out a lighter. He could have been pointing out a lotto ticket, a pack of cigarettes, behind the counter, anything really that they need to be pointed out, because maybe to point out something they wanted.
But as an observer in the police officer's position at the time, knowing what he knew, becomes part of a reasonable suspicion calculus, doesn't it? He knew 7-Elevens were being robbed. That's why he was where he was. Then he sees this guy reaching over the counter, which is why he reasonably follows the car when the car leaves the lot, right?
I would say he saw leaning over the counter, not reaching over. So just sort of leaning over. So it's a little bit less than reaching.
Okay.
And so, I mean, certainly you know, he can follow the car for that reason if he wants, but I don't think it really is part of, I think it's a zero in the reasonable suspicion calculus here, that it just doesn't add up to anything. It was someone possibly pointing out something they wanted behind the counter. And then from there, the detective follows the BMW down the street. He parks outside or next to Dingwell Street. He has no view down this street. The street is not a dead end like he thought. It connected to another major street. And he hears the sound of a gunshot. He's unable to specifically locate it. It came from the general direction of where the car had turned down. He does no investigation down the street. We don't know what the scene on Dingwell looked like. We don't know what the scene on Lexington looked like. And so we just have the general direction of the gunshot. The BMW emerges shortly thereafter and parks in a residential building, an apartment complex that happened to be Mr. Matos's apartment. And so without any further observations, there's really nothing linking that BMW to the gunfire. There may be some.
There's nothing linking the BMW to reasonable suspicion. He watches the BMW turn down the street. He hears a gunshot. The car returns, according to the testimony, within 5 seconds.
Mm-hmm.
There are no other cars on the street.
It's 2:30 in the morning.
Could be midnight. The specific he was.
There are no other cars on the street. As your sister emphasizes multiple times in her brief, right? Because it was emphasized in evidence.
Well, I think there were no other cars on Princeton Boulevard where the detective was. We don't know that there are cars on Dingwell, Lexington, or anywhere else, and we don't know where that gunshot came from. So there's no cars specifically right where the detective is, but given that there's no specific location of that gunfire, we don't know that there wasn't cars where that came from. It's double negative. But
it could have been another car. But all we're talking about is reasonable suspicion, right? Which is a pretty low standard. I mean, the SJC has said probable cause is a low bar. Reasonable suspicion is something considerably less.
well, I think that, for example, the Evelyn case does sort of help a little bit here, where that defendant was the only person that the police had seen on the street after a shooting. And just the fact that the defendant there was on the street doesn't necessarily mean they could have stopped and searched him. It was a combination of his presence, being the only person there, and the fact that
Evelyn your best case?
I think honestly my best case is Able A. I know that's an unpublished decision, but I think really the only difference between my case and Able A is that there's some people on the street in Able A that aren't the defendants. But I think that goes back to my argument. We don't know that there wasn't anybody else.
For a published decision, what are your 3 or 2 best cases? Is Evelyn one of them?
I think as a way of a contrasting case, yes. And I think, I'm probably not pronounce this right, Meneas.
Meneas, yeah.
Okay, thank you.
Yeah, the case about the kids in Cambridge, right?
Yes, exactly. I think those two. Evelyn is a contrasting case, I think, because they ultimately found that they had some reasonable suspicion to search him, but in part because there was observations of a weighted object in a pocket. He was walking with, I think, an unusual gait, things of those nature, that led the officer to believe that the defendant there had a firearm. We don't have anything like that here. Really, the only observations of any individuals prior to the stop is someone leaning over a counter. And other than that, there's no other observations of any specific person.
Any other cases you'd like to point us to?
I mean, I do want to quote Able A. I know, I think it is my best case, but so it is, essentially stands for that proposition of the flight of a person from an area where a gunshot was fired without more is not enough to stop. And so we here don't know what that BMW's involvement was with the gunfire. We don't know if they were even aware of it, or if they were fleeing it, if they were a witness. We have no concept of what happened where that gunfire was. We don't even know how far away it was, just kind of came from the general direction. So.
So if, I think for some reason I have a memory of a case like this where somebody's riding a bicycle away from gunshots.
That was another unpublished decision, Burton. I think that also stood for that same proposition, the flight of a person where a gunshot was fired without more is not enough to stop that. Actually, that quote, yeah, I think that came from Burton as well, Evan Burton. I think that's in my, it's after.
Not reasonable suspicion to stop someone who is riding away from a gunshot fast.
There wasn't in Burton.
I haven't read those cases in a while, but I have difficulty with it because reasonable suspicion, well, I suppose, I would think that you're able to stop them to see if they have evidence, but maybe that doesn't comport with the language of our case law. That's too bad, if that's true. I mean, you know, there's a gunshot. Somebody's riding away very quickly. Maybe they saw something, even if it's not them. Police don't have the ability to stop that person?
I don't believe so under our case law, especially unpublished decisions. Just simply running away from a gunshot is is not enough, just simply because we don't know their involvement with that gunshot. We don't know if it's a witness, someone being shot at, entirely uninvolved, excuse me, or anything else. There's no real shading or character to that
Hey,
kind of
did
action.
you see anything? Hold on, son, stop. Did you see anything? Unconstitutional.
I mean, I guess that sort of depends if that's exercising a police sort of power over the person. I'm not sure. I think in this case, well, clearly they.
Yeah, clearly there's a stop here.
Yeah, the stop
Or
lights are on.
There's a, yeah. Eventually, some exercise of coercive police power. I agree with that.
Yes. Yeah.
Do you want to argue your Bruin point, or?
No, we're waiving that, so that's, I think, no longer applicable. We're not looking for a decision on that. I think we filed a joint memo about that. So if there are no further questions, I can rest on my brief.
Hearing none, thank you very much, counsel. We will hear from the Commonwealth.
Good morning, and may it please the court, my name is Melissa Johnson. I'm an assistant district attorney in Middlesex on behalf of the Commonwealth. My fundamental difference with my brother here is that the officer here, the detective, not only had reasonable suspicion to stop the car here, just as in Ford, he had a responsibility to investigate what was going on here. As Justice Englander pointed out, against this backdrop of armed robberies that had happened to 7-Elevens in the neighborhood, there was a specific threat that the detective was aware of at roll call. He was asked to stay and investigate past his shift. And these armed robberies were conducted with dangerous weapons. So we have that against that backdrop. And then the detective realized that there was a diversionary call when he was at the other 7-Eleven, which caused him additional suspicion. Now, I am not submitting that all of these amounted to, by themselves, of reasonable suspicion, but just as Justice Singh had said in Ford, you can take the constellation of facts and look at them in aggregate to amount to a reasonable suspicion. So we have this against the backdrop, and then Detective D'Alessandro focuses on the only car in the area that stops at that second 7-Eleven, sees the guy leaning over the counter, which draws his attention to this particular car, decides to focus on this particular car, and at that point sees the car leave, go down what he believed to be a dead-end street, waits for it, hears a gunshot within the general direction of that car, and then within seconds the car reemerges, whips around to the same direction from whence it came.
Are you familiar with any published cases from this court or the SJC that say that you don't have reasonable suspicion to stop someone who's moving quickly away from the sound of a gunshot?
That we don't have reasonable suspicion?
Yeah, well, that's what your brother is saying. He's saying that Able A and perhaps the other case he cited indicate, but they're not published, indicate that you don't have reasonable suspicion to stop someone who's moving rapidly away from the sound of a gunshot. Do we have any cases that say that?
I don't, Your Honor. I don't have anything off the top of my head that could help my brother.
The problem, I
in this
suppose, is that
situation.
it says you have to have reasonable suspicion that they committed, are committing, or about to commit a crime, whereas I would just say they may well have evidence, And, you know, you can have probable cause to search for evidence. Why can't you have reasonable suspicion to search for evidence? Anyway, I'm just musing at this point. I apologize.
Oh, no apology necessary, Your Honor. And I do think this case really stands on all fours with Ford. Because you hear, it's not only the sound of the gunshot, which is going to cause this detective to have the duty to investigate, but in this particular instance, there's no other cars on the road. It's near 2:30 in the morning. And so that detective is almost compelled to follow this car, which is then whipping around back to the direction and then makes, as what he described, an unsafe turn into the parking lot. So it is my position, as the Commonwealth's position, that this is not only reasonable suspicion, but this detective really had a duty to investigate what was going on. We're talking about a thickly settled residential area where he hears the gunshot. And the reason why I distinguish the cases that my brother relies on, Matos and whatnot, those cases are really about a situation where a caller or another eyewitness ID is reporting to the police, and then they're trying to square a description of someone with what they're seeing. But here it's the detective himself who is the witness, the ear witness, the eyewitness, all of that. And he's the one that's making that judgment call within all the information that he already knows about what's going on in the city of Lowell at this time. And so given the constellation of facts here, the lack of other traffic in the area, the time of day, the hearing of the gunshot, it's the Commonwealth's position that there was reasonable suspicion here to stop the car. I note that there are no further questions. I would rest on my brief, and also as far as the Bruin issue, it appears my brother has conceded that, and so with that, and also Justice Milky, the Middlesex DA's office would just submit that it's been a pleasure to argue in front of you and wish you all the luck in your retirement. Thank you.
Thank you very much, counsel. Thank you both. The case is submitted. We are going to take a very brief mid-morning break, only about 10 minutes. So we will see the rest of you who choose to stay after that. Thank you.
All rise. So we'll stand in recess. Let's make sure all phones are on silent, please. Court, all rise. The court is now open. Please be seated.
Thank you all very much. We are back on the record with our fourth case of the day. I can find my handy slip. James Todino versus Twitter, Inc., et al. The floor is yours, Mr. Todino. Oh, just the docket number 2023 P588.
Hello, my name is James Todino, and I am the plaintiff or appellant in this case. I guess the argument would be the defendant's motion to dismiss should have been denied because the motion judge failed to consider the claims relevant to the conduct of the defendants themselves, whether it was beyond doubt that no set of those facts could entitle for relief.
Could I, before you get started, could I ask a housekeeping question? You filed an original complaint. At some point, you then moved to amend your complaint. The motion, as I understand it, was allowed, but the defendants say you never actually served the new allowed complaint. We're trying to figure out what is the operative complaint here, the original complaint versus the one you got permission to file.
Well, each case has some similarities, but a little bit different. Pretty much the majority, the reason why I'm bringing it up is because of the, let's see, because of the argument that I'm trying to debate. I do have some pointers that I'd like to bring out on the case, that I'd like to distinguish the case from the CDA argument that the motion judge laid down to allow the motion to dismiss, if I may. One, the judge found that the defendants are internet service providers. Two, the complaint about the defendants is directly due to the anonymous third-party postings online. And three, that it would legally treat the defendants as if they were the third-party posters. The judge had to find all three items in order to allow the motion to dismiss. I agree with the first findings that the defendants are internet service providers, but I disagree with the second and third findings. On the second finding, the complaint is focused on the defendant's actions themselves, not the third parties who posted the things online. Obviously, the third parties who posted it is context on the case, but it's the actions of the defendants themselves at the issue here.
What actions do you allege that the defendants themselves, first of all, can I just do a housekeeping thing? One of the defendants in these cases actually published a book, right?
Correct, Your Honor.
Yeah, but I don't see anything in your appellate brief that addresses that issue. That case was dismissed on statute of limitations grounds, right?
I would like to argue that as well, Your Honor, the statute of limitations.
Well, but it's not in your brief. In your brief, you don't address at all the question of whether that was proper. And that's an entirely different set of issues, right?
Correct, yeah.
Okay. Well, did you make an argument below as to whether the statute of limitations, as I understand it, the book was published in 2004 and your complaint was filed in 2021?
Well, all the defendants here, I'm trying to come across, they were knowingly and reckless for allowing...
But sir, if you could answer my question, do you have a separate argument with respect to that was made below? What was it?
In the cases for the discovery rule, I think should have been applied by the motion judge. That was a mistake because the claims were not inherently unknowable when many of the evidence was presented, but it was overlooked. I should get the opportunity to at least toll statutes based on the discovery rule for when the claims were discovered or learnt of the harmful statements. I was unaware of the publications until 2019, according to all the evidence and police reports that were provided. I was also legally incapacitated and hospitalized over the years due to the defendant's negligence. So further evidence of why the discovery law should apply.
I understand that argument. So why don't you turn to where I interrupted you? You were going to talk about your other arguments with respect to those defendants who are internet service providers.
Then this is regard to the CDA argument?
Yeah, I think that's where you were. You can go wherever you'd like.
No, I can go back to that. That's fine, yeah. So I agreed with the first, the second one, it was the context of the case that posted online. It was the actions of the defendants themselves that was at the issue. The third one, found by the motion judge, that I'm not treating the defendants as if they were the third parties who posted online, but instead the defendant's own conduct that I'm complaining about. The motion judge didn't argue a large amount of facts that I brought up that would have allowed the motion to dismiss, narrowing the case the way the defendants wanted.
So what is the conduct of the defendants that you want to point us to that you think takes this case outside of the
It's knowing and reckless facilitators on a vast array of criminal acts against me.
And those facts are what? What shows
Those facts and reasons.
Whichever defendant you want to start with, what shows that they were knowing and reckless facilitators?
I did map it out in my briefs from pages 17 to 278. In the brief that was submitted. And the motion judge denied the motion to dismiss because it showed that I met the minimum standards of winning the motion, but I have to make at least a bare silhouette of a case for liabilities of the defendant. So as a result, the defendants could show that it was beyond doubt of no set of facts that could make them liable. I do have a copy of the appeals brief as well, if you'd like me to submit it to you guys.
No, we've got your appellate briefs.
Now, Mr. Todino, you, at least in some of these actions, including the one, for example, against Facebook, you do bring a case against a John Doe. And I'm going to ask the other side this question in terms of why that count was dismissed. The John Doe, I assume you're referring to, is the perpetrator of the false statements, et cetera, correct? The unknown?
Yeah, correct. Yeah, they were anonymous impersonation accounts. There was hundreds of them.
Where were the anonymous, which platforms? Because I saw that allegation in some complaints and not in others. Google was one platform that had anonymous impersonation accounts. What other platforms had them?
Pretty much all the social media accounts that you can think of had them.
Including Facebook?
Including Facebook, yep. Twitter had it for over 10 years when I kept showing them police reports. Same as Pinterest. Pinterest, they allowed pretty much these images that cause damage. They would claim the Section 230 for the broad protection can shield them from responsibility to failing to remove these fictitious accounts that violate the law. Pinterest is negligent, though, because they were made aware that they were aiding and abetting in terrorism on their platform, and they allowed these anonymous impersonation accounts to post graphic images of nude children and people being tortured on the daily. Even after multiple emails and police reports, Pinterest chose to ignore this code of conduct and continued to keep posting these accounts active as today on their platforms, causing catastrophic damages to the plaintiff and violating state and federal laws, and they are not protected by the First Amendment.
Now, the judge did not appear to consider whether your claims against the John Doe defendant could go forward, even if the other parties were shielded by the immunity provision. Did that come up during the...
It did not come up, no. I guess that's everything I really needed to present. If you have any questions, feel free.
I think we'll leave that there and hear, I believe, first from Facebook's attorney.
Thank you.
Thank you, sir.
Good morning, Your Honors. Congratulations, Justice Milky, and may it please the Court. My name is James Flynn, and I represent Facebook and Mr. Zuckerberg in this appeal. On behalf of Facebook, Pinterest, Google, Horseneck Media, and Twitter, I intend to argue that Mr. Todino's claims were correctly dismissed under Section 230 of the Communications Decency Act. And I think as the Court is aware, my colleague, Ms. Zuckerman, will argue the statute of limitations defense. Mr. Todino has at various times conceded that all elements of Section 230 are satisfied here, although he disputes two of them now. And he raises a series of exceptions that were absent from the record below and absent from his complaints and don't apply here. The Court has four different ways of affirming. First, it could conclude that the Superior Court correctly applied Section 230 to bar the claims. Second, it could conclude that Mr. Todino waived all of the arguments he made to the Superior Court by not making them here on appeal, and vice versa, waived all of his appeal arguments by not making them in the first instance to the Superior Court. Third, Mr. Todino's claims are similarly barred by the First Amendment. And fourth, even setting aside all of those obstacles, he fails to state claims for defamation and negligence, which are the claims he raised below.
Okay, could you address my question, which is focusing on the count, and it's at least in the Facebook complaint, against the John Doe? I assume you would agree that John Doe, whoever he or she is not protected by Section 230, correct?
I don't know who the Does are, and I think without further factual allegations, it would be hard to know, but I think in principle, yes, if they had made defamatory posts.
Isn't the allegation that John Doe is the person who actually created the content?
Yes, and so assuming
well, then how could they be protected by 230 if they're the content creator?
I agree.
Whether that's Facebook or anyone else.
So is that Mr. Todino's his remedy? Mm-hmm. I mean, here is someone that, based on the procedural posture of this case, we have to assume that his allegations are correct about his life being ruined by anonymous parties. Is his remedy, at least initially, against the John Doe parties?
I agree, Your Honor. There are a series of remedies available to Mr. Todino.
Help us understand this.
Sure. So one would be a John Doe action. He filed against John Does here, but never served them. He also filed a separate...
Help me understand how you serve John Doe.
Well, you investigate and determine who those John Does are. You serve subpoenas for that information. So Mr. Todino filed a separate John Doe action in California State Court. There was back and forth on subpoenas that was never resolved, and he failed to appear in response to an order to show cause why that case should not be dismissed. It was ultimately dismissed for failure to serve anybody. Separately, Mr. Todino filed complaints with the Massachusetts Attorney General, that's at page 151 of his appendix, with the FBI and the CIA and the Department of Justice, that's at page 152 to 165. He filed a police report with the Woburn Police Department, that's at page 124 to 129. And he agreed with the police department's conclusion that none of the posts in question threatened him or were directed to him specifically. Lastly, at page 126, that's part of the police report, Mr. Todino reports that he hired a forensic legal group in California to investigate who the John Does might be, but he conceded to the police that he never followed up with them because he was busy. Finally, he hired a separate digital forensics group that did turn up two names for possible John Does, although it appears at least one of them might have been a fictitious name.
Let's assume, for the sake of argument, he's unable to identify John Doe. So he brings a true John Doe complaint. Is there a way of serving that and getting a judgment against John Doe?
I believe he would have to first identify the John Does via subpoena discovery against perhaps the platforms or other internet service providers, or otherwise investigate that information. I don't know, Your Honor, whether he could get a judgment against an unidentified John Doe. That I'm not sure.
And assuming hypothetically he were able to get a judgment against John Doe, be it identified John Doe or John Doe, what in 230 bars a claim against your client to take down. Say John Doe won't take it down. He presents you with a judgment requiring John Doe to take it down. Why isn't this like a reach and apply action, say, where I'm not saying the bank is liable, but the bank's holding the money against which I have a judgment?
Understood, Your Honor. Section 230 would still bar that action against us to enforce a judgment against a third
Other
party.
than the Hassel case in California, are there any other courts who have dealt with that issue?
I'm not aware of them in the post-judgment context. I can say that several courts, including the First Circuit, have held that you can't bring an action against a platform for the mere refusal to remove a post, and I think that this.
But isn't that a different posture than when you have a judgment against a third party requiring the removal of the post, and all you're trying to do is to go back to the internet company or social media company and say, I have a judgment, they won't take it down. Again, reach and apply type analogy.
That well maybe, Your Honor. I haven't looked into the issue and can't take a
So
position
you don't know
on
of any
that.
cases on that subject?
I don't. I'd be happy to look into it if Your Honors would like supplemental briefing on it.
So just before that, you said something which I was going to ask about, which is there are a number of cases which you say insulate the internet providers from a lawsuit that says, I asked you to take this down because it was harming me, and it's false, and you didn't do it.
Yes.
And what cases, so that allegation appears in a couple of these complaints, right? Does it appear in the complaint against Facebook?
I don't believe so. Let me confirm that.
But I did see it at least once, maybe twice, that I asked them to take it down, take down these false statements. They did not do so.
Agreed. I believe that's in the complaint against Google at Google's supplemental appendix at 5.
And you're appearing on their behalf too here?
Yeah.
Okay. So you say that claim is barred by Section 230.
Yes.
And the case you rely on for that is?
Universal Communication Systems in the First Circuit, Clayman in the D.C. Circuit, and also D.C. Circuit, Marshall's Locksmith. I'm happy to provide those citations.
And the reasoning behind those cases is that that's a publishing decision.
That's right. It's an editorial function. It would be treating the defendant as the publisher. I'd point also to the SGC's case in Turo, where they held that Turo's independent Turo served two roles, a quote, dual role. One was Turo creating its own advertising, providing its own pickup services. That was conduct that could be enjoined by the court in that case. But the second role for Turo, the hosting, the not removing, the allowing posts, that second role was barred by 230. And so the SJC carved out that part of the injunction because it was not proper for the trial court in that case to enjoin as to the removal of posts by Turo.
What was the allegation in Turo as to why the posts needed to be removed? I'm sorry, you're going to have to remind me.
This was the case about airport rental cars and an app that allowed folks to post third-party car rentals. And Massport expected that there to be written authorization in advance of allowing those listings.
What the defendant says here is, what the plaintiff says is, he says, look, I asked you to take it down, and I explained to you that this contains false and defamatory information. And in fact, I think the most extreme is, that's not me. That person who's using my name is not me, and they're putting stuff in there that's ruining my life. And he says that's a claim that is based on your conduct, that it's essentially negligently responding to what's on your website. And you say, no, that's 230 prevents that because that's a publishing decision, right?
Yes, Your Honor.
Is there a case on exactly those facts? Because I picked up the First Circuit case written by Judge Selya, and I didn't see it there. How those facts is a little bit different.
I believe that is Universal Communication System against Lycos in the First Circuit. That's 478.
Lycos, which predates the Selya opinion then.
I think that's right.
It's back page. The Selya opinion is back page.
That's right. In Lycos, at page 478 F3rd, page 420, the First Circuit explained that notice and request to removal is not enough. Section 230 still bars that claim because it is an editorial function.
And I take it there's no case out there anywhere that that accepts this theory. Hey, I asked you to take it down, I explained to you that it was false and fraudulent, and you didn't do it, and you're separately liable for that?
I'm not aware of any, Your Honor, and I don't think Mr. Todino has identified any. Return, just I acknowledge, oh, excuse me, sorry. My colleague reminds me that many of these platforms do consider takedown requests and do investigate them. It's just a question of Section 230 liability for that act. To your point about there being multiple impersonating accounts, this was also something that was raised with the Woburn Police Department, and it appeared, at least in some cases, that there were genuinely other James Todinos, and so not all of the accounts, I think, could correctly be identified as impersonating. On the second element, whether the platforms provided the speech or whether it was the speech of the third party, I hear Mr. Todino to challenge that now. He conceded it in the trial court below. The Superior Court found that fact at page 74 of Mr. Todino's appendix, and it walked him through that analysis twice during the hearing. And in both instances, Mr. Todino agreed that he had no evidence or reason to believe that one of the employees of the defendants was the source of the speech, that it was anonymous third parties, as he alleged in his complaints.
Could you get back to my initial question? What is the operative complaint?
Just headed there, Your Honor. So we agree that the amended complaints are operative here. They weren't included in Mr. Todino's appendix, but the defendants supplemented their own appendices with those complaints. You might be referring, Your Honor, to the service issue as to the other non-complaint materials that were filed after the motion to dismiss litigation. There were some additional filings. One was called a motion for additional statement of claims or statement of additional claims. Those items were not served on the defendants properly and weren't filed as part of a motion to amend. And the Superior Court again twice.
The judge seems to have been relatively loose in inviting factual allegations from the plaintiff, correct?
I wouldn't agree with that characterization, Your Honor. Twice during the hearing, he walked Mr. Todino through, we have these complaints, that's what I'm considering at the motion to dismiss phase. You've made these other filings. I can't consider those. They are not part of the case until you've served them and filed the motion to amend. And Mr. Todino twice agreed that he understood that that was the case.
Is the hearing, I looked, but the hearing transcript in our...
I don't believe it's in the appendices. Mr. Todino didn't include it. If the court would like, I'd be happy to provide it. And the same as to the question of the John Doe judgments. Just let us know if you'd like the supplemental briefing on that.
If we want a supplemental brief, we will ask for it.
Yes, Your Honor. Thank you.
Appreciate the invitation.
Yes. If there's nothing else, I'll hand it over to Ms. Zuckerman.
Thank you very much.
Thank
we
you.
will hear from Attorney Zuckerman.
Thank you. Good morning, Your Honors, and may it please the Court. I'll be addressing the appeal as to what I will refer to as the statute of limitations defendants. These are Condé Nast, Advanced Magazine publishers, the O'Reilly defendants, which is Mr. O'Reilly, Mr. McWilliams, and O'Reilly Media, Inc., and to the extent that the motion to dismiss decision was based upon the statute of limitations, also Horseneck Media. For very, very brief context as to how this group of defendants differs posturally from the prior group, the record allegations as to these defendants were briefly, Condé Nast published the magazine Wired, which in 2003 carried 2 articles about a man named Robbie Todino, which the appellant claims were defamatory to him. The O'Reilly defendants published a book in 2004, which also referred to Robbie Todino, and Horseneck Media published an article in 2013 on a website that it now owns, which is called Bro Bible, which apparently also discussed appellant. As Your Honors noted, appellant has not addressed the statute of limitations in his moving brief, so it should be waived as to these defendants. To the extent that Your Honors are inclined...
Publications were all roughly around 2004?
Your Honor, there were 2003 and 4, and then later, about 10 years later, 2013, but all well outside the 3-year statute of limitations for the complaints which were filed in 2021.
What was published in 2013 that differed from what was published in 2004?
It was an article on a website known as Bro Bible, which is, the website is now owned by Horseneck Media. In each instance, Your Honor, regarding the statute of limitations argument, what Mr. Todino complains of is a article or articles published at ascertainable moments in time, which is why they're outside of the statute of limitations. Based upon what's been alleged here, as to the Wired articles, they were approximately 17 and a half years old when the complaints were brought. The O'Reilly book about almost 17 years old, and the Horseneck Media post, some 9 years old. These are all well outside the 3-year statute of limitations. Mr. Todino referenced the discovery rule, and it's simply not available on these facts, Your Honor.
Did he make that argument below?
Yes, Your Honor, he did make the
Supported by
argument.
what facts?
Based upon the fact that he did not discover the material until he conducted a Google search in 2019. At the time, he was running for office in the city of Woburn. And at that point, he was able to access the articles through the internet. And the Superior Court judge below correctly found that this, combined with other facts, such as the dates upon the publications, which it correctly considered, established for the court that this was not inherently unknowable. The discovery rule only applies, of course, if publications are either inherently unknowable, concealed, or confidential. There was no allegation of concealment or confidentiality, and they were not inherently unknowable because, as Your Honors are aware, there is an objective piece to that standard. It has to be not just unknown by the appellant, but it has to be not able to be known through reasonable efforts.
But this was done through an affidavit of some sort on his part that said, I didn't read this until 2019?
It was a factual allegation in, I believe, both versions of the complaint, Your Honor.
I think we're going to have to leave it there.
Thank you very much.
Thank you all very much.
Congratulations on your retirement, Justice Milky.
Thank you. The case is submitted. Our next case is 2023 P1022, Samu versus Sundaresan. And my apologies if I mispronounced anyone's name.
Nice to meet you too. Arrived just a bit late. May we begin?
Yes.
Good morning, Your Honors, and may it please the court. I'm Attorney Maureen Booth. On behalf of SIVA, I'm going to try that again. SIVASUBRAMANIAN.
Folks are free to sit down. You don't have to stand.
With me at the bench today is my associate, Attorney Melanie Fox, and my client is in the courtroom with me today. As Your Honors have seen from our brief, there are several issues raised. The crux of our arguments, Your Honor, is that while Judge Christine Anthony claims in her rationale to attempt to fairly balance the parties' sacrifices, we feel that at every turn, the judge improperly used her discretion or even erroneously applied the law to tip the scales in favor of the wife and against the husband, who is the primary caretaker, in fact, the sole caretaker of the party's 10-year-old child. This is, mind you, an 11-year marriage. Under the statute, the durational limit is 70% of the marriage, so it should have been approximately 8 years of alimony.
Maybe we can cut through some of this because, as you know, we've read the briefs.
Thank you, Your Honor.
I have a couple of factual questions which I had difficulty with on what I had. How is it that the wife, the judge says that the wife asked to modify the durational limits? Was that in a motion? Was that argued? How is it that she asked to modify?
And that's an excellent question, Justice Englander. I appreciate that. My understanding is that that was only in her proposed judgment. I was not trial counsel, but the only place I saw that was in her proposed judgment. I read the trial transcript. I didn't see it in the trial transcript. I only saw it in the proposed judgment.
And what did it say in the proposed judgment?
Just that it be extended.
Was there any argument as to what facts would allow it?
And that was my question too, Your Honor, because I would suggest that under these facts, it would not have been
Let's answer my question first.
Thank you.
Were there any facts provided when the wife asked, hey, modify the durational limits? Were there any facts provided as to why that should be?
Only I think she only relied, and again, through her Section 15 guardian, which was appointed by Justice Anthony. The brief was submitted, and I think they only relied on the facts of her having the current mental illness, which the parties stipulated to, Your Honors.
Right,
that-
but there was nothing about, so your position is there is nothing about whether this is a temporary or a permanent condition, nothing about whether it's treatable, nothing about how it's been treated, nothing about whether it was being treated at the time that these events occurred.
That's incorrect, Your Honor. That's not my position. My position is not there's nothing. My position is that all of the evidence says that it's current and that even the GAL said, and if I can flip to it.
I'm not sure what I was wrong about yet.
I'm sorry.
What was wrong about what I stated?
I'm sorry to argue with you, Your Honor, but
No.
not that there was nothing.
No, that's what we're doing here. We're
Yes.
trying to, you need to set me straight.
And I appreciate that. Not that there was nothing. The evidence was all that. The GAL said ultimately the diagnosis and treatment still need
Is
clarification.
uncertain. That's what I was saying.
Uncertain, yes.
She was
And that it's
mentally ill at the
current.
time. However, there's no evidence as to whether it was being treated at the time that events had occurred, right? For example, was she taking medication that was provided to her, whether it was treatable in the future, whether it was permanent. No evidence on any of that.
No evidence on whether it could be treated or whether she would be able to have employment in the future. And I remind you, she had just gotten her master's degree in 2018. This trial was in 2021. And she had been employed, and there was evidence, trial exhibit.
Whose burden was it to produce such evidence?
I would suggest that it was the father's, but the father had put in evidence that she had worked in 2019. That was disregarded from what
Why
I
is
see.
it the father's burden?
Well, I guess that's
Well,
unclear.
the statute which we're applying says that the presumptive duration is 70% of the length of the marriage.
I would agree.
Why isn't the burden on the wife if they want the presumptive length to be adjusted?
I certainly agree with that, Your Honor. And that in and of itself, I would suggest is clear error, that Judge Anthony
No,
took it upon
I
herself.
read the judge's decision to, in fact, be putting the burden on the wife.
Certainly to extend the durational limit.
Okay,
The burden
so,
would be on the wife.
I'm looking at the portion of your brief that discusses George versus George. Do you read that case to be saying that this issue can only be raised through a modification complaint? Or are you saying it could in some circumstances be raised at the time of divorce, but the evidence here wasn't sufficient to warrant deviation?
I believe, Your Honor, George versus George is a modification case.
Right.
But I believe that it indicates or alludes that it could be raised, and I think it actually says, that it could be raised at the divorce, but just what you said,
Well, actually,
Your
it doesn't say that. It says the judge should evaluate the circumstances in the here and now rather than at the time of divorce.
Yes.
What does that mean? I mean, so it seems to be implying that it cannot be raised at the time of divorce.
Well, I'm sorry, I'm a little jumbled at the moment. I think that if you are to raise it at the time of the divorce, it has to be clearly a disability that's going to be for life.
So it's the burden on the recipient spouse if the request is made at the time of divorce to show something that's permanent.
That's certainly what I would
okay.
argue, Justice Shin. And a nod to Justice Milky here on his last day. He had a very similar case in 2017, I believe, an unpublished case. If you recall, Justice Milky, the Morse case, you may not recall, but I found it because it helps me. And it was very much on point, and you argued the exact same thing at the time, or, you ruled in the exact same way, where they wanted to extend the durational limit, and you essentially said, no, you can do that on a modification. That you keep it within the durational limit now and argue the same.
This is an unpublished opinion?
Yes, I can give you the site, Justice Shin. It's Morse v. Morse, 16P 1620, December 13, 2017. It's 92 Mass App 1118. Oh, no, I'm sorry, I was incorrect. It's not an unpublished case.
It's not an unpublished case?
No. 92 Mass App 1118, Morse v. Morse.
1118 would just be the reference to the unpublished.
Oh, okay, I'm sorry. Yes, I'm sorry. I'm sorry. May I continue? Thank you. So, setting aside the error of law that we believe that Justice Anthony made regarding the durational limits, Your Honor, regarding the ruling on alimony and that she didn't also deviate for child support, she set alimony at 32.5%, which, of course, under the statute, she's allowed to do. But in that, under the Kavanaugh decision, she included $13,318 of father's employer's contribution. So she included that as income to him, and then set alimony at 32.5%. She has the discretion to do that, of course, within the statute. But then she didn't also deviate upwards for child support, which, I briefed that. I think the point ultimately that I'm getting to, and I may run out of time before I fully make this point, is that in each time she had the discretion, she weighed in favor of mother. And that the total cumulative effect of that is that each drop in the bucket created a situation where father literally cannot pay this alimony award. He has, at this point, paid roughly half of his alimony that he owes. He's in arrears. He has no assets left other than the 401k. And under our law, as you know, I'm reading from Katz v. Katz, in setting an alimony order, the trial court must consider whether it is setting an order with which the payor can comply. Justice Anthony, I think, should have looked at the overall order and seen, wait a minute, I need to create an order that this guy can pay.
I don't understand how it is that you say that he can't pay his alimony. He makes roughly $150,000 a year, right? He's been ordered to pay a third of it, right?
Roughly, yes, sir.
Yeah. And he has himself and a child to take care of on what remains, which is 90-something thousand after taxes, right?
Yes, sir. I have his financial statement here. He pays...
And his financial statement said he was going to be spending $1,500 a week, which I think comes out to be about $75,000. So I don't understand how it is, based on the numbers in the papers, that he can't pay his alimony.
Well, she ordered alimony at $984 a week, and then gave him $190 in child support. Right. So that's $794 that he pays her.
Comes out to be a little over $40,000 that he's going to be paying.
Right.
Okay.
But then she's
out of $150,000.
Yes, Your Honor. But then he pays all of the child's expenses. Huh? She stripped from him she took all of his, what she saw as his voluntary expenses, which were his retirement, college savings, and she allowed him his trip to India, but then took away his voluntary expenses,
right.
his savings for that.
They're in a difficult
she didn't take any of
situation,
the
which the judge acknowledges, but the numbers, my reading, I can understand that it's a very difficult situation. I can understand, and I'm sympathetic to your client's position, but I don't understand how he can't pay the alimony. That's why, the numbers don't add up to me to say, oh, I'm sorry, I just can't make it. Well, at the time, which was a few years ago, he had $1,550 in expenses per week. That's less than he's going to have after he pays alimony, based on what I was reading.
I'm sorry, I'm not following what you're saying.
I've given you a bunch of numbers to work with. See, if you're going to stand up here and tell us he can't pay, This was a fundamentally wrong order.
Yes.
You need to have command of the figures. You need to be able to explain to me how it is on $150,000 paying $40,000 in alimony that he can't pay. I can't get there.
Okay. Well, his after-tax income is $1,900 a week. His expenses are $2,800 a week. So
But that's not what the judge's order says. The judge's order says his expenses are $1,500 a week.
that's because she stripped from him things that she said are voluntary, but which perhaps maybe aren't voluntary, or which,
Well, one of them is saving for college, right?
that's what, yes.
But, I mean, the judge is saying, look, given your situation, you're not going to be able to save for the child's college. And that's awful, all right? Nobody wants that situation. But the judge has said, I considered this, and this is the way I came out. And on our review, we review that for what? What's our standard of review?
Well, but Your Honor, also don't forget, when she, by her own math, he was already $500 in the hole every week, by her own math, even in her order.
Not $500 in the hole at $1,500. That you can't sell me on that.
It's in my brief. I don't off the top of my head.
All right.
But I did go through that math in my brief, sir.
Could I ask you a question?
Yes, please.
You rely in your brief on the actual sale price of the marital home,
Yes.
which was raised in the context of the post-judgment motion, right?
Yes, Your Honor.
Did you file an appeal, or not you, but trial counsel, file an appeal from the orders on those post-judgment motions?
Trial counsel did not. We filed the two post-judgment motions, which were,
So how are those issues properly before us?
well, I guess just on the post-judgment motions, only on that. I think only just that we added them to our brief, but I guess
But without a notice of appeal, those
Yes.
orders are not before us?
Yes.
Okay.
And I see that my time is out, so I guess I would just submit the rest of the case on the brief.
Thank you very much.
Thank you, Your Honor.
We will hear from the wife.
Your Honors, it pleases the court. My name is Attorney Marcus Scott. I'm here to argue the appellee side. Before we begin, I should make it clear that my client suffers from mental illness and wrote her own, was pro se up until this is Monday. I think I was hired on Thursday. And I am going to do my best to make things coherent, if that means something, if that
Understood,
if you understood that. Okay. The first thing I would like to do is talk about in my introduction is just state pretty clear that, and I'm thinking of a joke that I heard when they told me this, which is about when dealing with alimony and the division of assets. They said if you're a millionaire, if you have $5 million and you're ordered to pay half of that, well, you're not starving. But if you make $30,000 and you're offered to pay half of that, well, then you're in trouble. The idea here is that from what I've seen, and from what I've looked at, from what I've talked to, the appellant, the plaintiff, has the money, just doesn't want to pay it. In dealing with my client, the thing that I was told was that there was a lavish lifestyle that he was having, but most of the time, the things that he did based on not one job, but two. So we've got one gentleman who had two sources of income, and those two sources of income totaled more than $150,000. And I have a wife who did not work all the time, spent a lot of her time taking care of the baby and taking care of the house and being the homemaker.
Counsel, isn't that part of the issue here, which is the father has almost full custody, so he is taking care of the child, and his argument is, I can't both get a second job and not commit malpractice as a father. How do you respond to that?
Well, I respond based on the fact that he was doing consulting. And the consulting that I was told he was doing was tantamount to being home and dealing with consulting that way. He didn't have to fly all over the country.
Is this in the record at trial? And I know, look, I appreciate your being here and doing the best you can. So if your answer is, I haven't had a chance to review the entire trial record, I get it. But was it in the record what he was doing to earn his, on the second income?
I have no idea.
Okay. So there's sort of two components to this, right? One, Judge Milky's raising, which is, you know, 2 jobs and raising a 10 or 11 or 12-year-old now maybe is pretty tough.
I agree that it has some challenges, but the bottom line is, in all of this, is that he's expected and was expected to handle such challenges. The child wasn't a special needs child. The child was happy, healthy, and well-adjusted, going to school, doing the things that he's supposed to do. What we're looking at is the complaints that I've read and the things that I've seen is that he was complaining about things like extracurricular activities. Well, just like you stated before, sometimes you maybe have to take away some extracurricular activities to save the time that you do have with the child.
Okay, here's where I'm having trouble. So after taking away some of those, what the judge termed to be voluntary expenses, she found his weekly expenses, I believe, were $1,500 something. And then she says, after the payment of alimony and receipt of child support, his net income will be approximately $53,826 per year, which comes out to $1,035 per week. So how is that justified? So that does basically leave a shortfall of $500 per week.
I didn't see that shortfall, Your Honor. I saw amount of money that he made versus the expenses that he was given. Subtracting that, he had money left
Unless
over.
her math is wrong, she says after payment of alimony and receipt of support, his net income is $1,035 per week. And she had calculated his expenses to be $1,500 and something.
Then he needs to address what his expenses are and deal with it accordingly.
Okay. Could I ask you about the durational limits?
Sure.
I find George versus George a little confusing, but one aspect of it I think that is clear is that for divorces, divorce proceedings that are commenced after the Alimony Reform Act, the burden is on the recipient spouse to prove that deviation is appropriate. So here, without evidence that her mental illness is permanent, how did she meet her burden?
I think she makes her burden by showing up and dealing with the court over the course of, before the divorce itself, there was a lot of hearings to determine whether or not she was coherent or not. I know I was one of the attorneys that argued for that. And it was basically stated in the GAL report, it was basically stated by her doctors that she was not in great shape as far as her mental illness was considered, and that it could go on permanently. She had suffered such mental illness because of a stillborn child and some other things that are going on.
It could go on, but the burden, again, is on her to show that it's going to go on beyond the durational limit. And I know you're new to the case. Can you point us to any evidence that would support that?
I understood George v. George, and I understood some other cases to mean something a little different. But if I may, the thing that I'm very, very concerned about, or what really is the point of it, is that if you look at the DeCastro case, DeCastro v. DeCastro, which was 475, Mass 475, I'll provide an address for it in a second. We're dealing with 5% because being a homemaker in the DeCastro case was basically enough as being a business person. So we're dealing now with 5% because it was 50-50, and now we're dealing with that 5%. That 5% came out in her mental illness. So the judge did the right thing in assigning, in making the the equity, my tongue's a little tired, I apologize. The judge made the right decision based on the fact that she had a mental illness, and it knew that, and everyone knew that. It was in the record. It was in the record.
But in terms of the durational issue, at least,
Yes.
where the record seems to be, if not, I mean, maybe the record is as complete as it could be at the time, but we don't know how she is going to be in, say, 8 years. Why wouldn't the proper thing to do is to push the decision on duration down the road, and to the extent that the wife continues to suffer from the mental illness, to file a complaint for modification at that point, as opposed to try to guess at what's going to happen now?
Because she wasn't in the condition to do such. We don't know because she's not in the condition to do such, Your Honor. We don't know where she's going to be 8 years from now. What you're stating to me is that why can't we just push this down the road, and in the end of 8 years or whatever the time is, then she enters in a modification and goes through the process of beating the durational limits argument.
But as the
But she
things
wasn't-
currently stand, it's the husband who's going to have to move for modification,
Yes,
right? And George seems to say it's the other way.
I didn't hear you, I'm sorry.
George seems to say that the burden is the other way, that it's the recipient spouse who bears the burden.
And if the recipient spouse bears the burden, I think the trial court took into consideration her situation, excuse me, again, a little tongue-tied, took into consideration her situation, the fact that she was mentally ill, and the fact that she probably wasn't going to be able to respond in a legal manner that the court would understand. I mean, I don't mean to insult her. I don't mean to insult her.
Are you familiar with any proof in the record that supports what you just said?
Most of the proof in the record is that I got was from my extensive interviews with the.
But that's got to be in the record, sir.
So, but in the record, what I found was the guardian ad litem reports that basically said that
She's mentally ill.
She's mentally ill.
She had been treated for it in India
Right.
with medication.
Right.
We don't know if the issue was that she'd stopped taking her medication. There are indications in the guardian ad litem report that she had stopped taking treatment. So we don't know, at least on the record I'm reading, whether it's permanent or whether it's treatable.
But then you'd give her the benefit of the doubt. The benefit of the doubt based on what she's gone on before.
It's her burden of proof, and that sounds the opposite of her burden of proof to
But
me.
she can't prove any, true, she can't prove any burden because of the situation she was in.
Well, she had counsel. And she has competent counsel now, too.
That counsel now who basically is flying by the seat of his pants.
But you're navigating well, sir.
Thank you. I appreciate that. The idea is that, and what we're hearing from, is that the burden is on her. The problem is that she could not meet the burden because she didn't have the help that she needed to do such. The burden of saying that her mental illness is going to extend further and further, we have a guardian ad litem report, but she was her own lawyer for a while, and then what happened was that she got a lawyer who basically didn't represent her to the extent that she needed to be represented, because any lawyer would have put that in the record, at least would have tried to put it in the record. And in reading the briefs, and I read her brief and I put it away. One of the things that I can say is that she is in a bad situation, and the trial court judge had to take that into consideration, and did. And she did it based on what the law says that you can do. So here, what we're looking at when we look at things like Kittredge and Katz, there was not something that was, there was not an award that was wrong or excessive. Excessive doesn't count here because of the fact that he actually did make the money. It comes back down to that. It comes down to the fact that he made the money and was able to afford it, but is crying poor. He's crying poverty. It's like, when I was reading this and researching this, and this is how I think, I apologize, but I remember an episode of The Simpsons where the millionaire said, "I don't have any money," and then got hit with, and then a trail of dollars hit him in the face coming through the ceiling. It's the same thing. He's sitting here crying poor.
One thing we're going to have to get to the bottom of is the finding that Judge Shin just pointed out, which is that he only had $1,000 a week after taxes and after payment of alimony, which I can't see how you get there from $150,000, but
I can't
we'll have
either.
to take a look at it.
When I looked at the numbers, I said the same thing, Your Honor. He makes the money. The record shows what he made.
There's a finding of fact.
And there's a finding of fact. All the stuff we looked at, we couldn't find a reason why he couldn't pay. That's why I sit here and saying he's crying poor, or he's crying, I can't. He's doing I can't, but yet all of this is hitting him in the face. The properties that he has, the bank accounts that he has, but more importantly, the salary that he has and his extracurricular activities, which we feel, at least according to his wife, that he can do and still maintain his son and still maintain his household. It comes down to some ideas whether or not he's crying poor or if it's being real, and based on the numbers, it doesn't make any sense. He has the money, and if he has the money, then he has to pay. I don't think the trial court looked at a situation where he actually couldn't pay and then just decided to be mean. They took a look at the numbers in the record and said he can pay. There was a decision he can pay. And remember, under DeCastro, we're not talking about 10%, we're talking about 5%. Because if it was 50-50, it's 50-50 because what she did in the household is the exact same as what he did in the household. So now we're at 50-50. So then we go to an additional 5% based on the fact that she had a mental illness that everybody knew about. And that mental illness, it was her, the idea is that the court understood and knew this burden and had to act accordingly, which was in their right. All she had to do was spell out the rationale, and which is what she did. And she essentially said just that there's no telling when she's going to get better or if she's going to get better. She's in a very bad place. That came from the court themselves.
Although the GAL seems to say we need more information.
And I agree, the GAL isn't any more of a licensed clinician than the judge is, but the idea is if you've ever met, and I'm saying this respectfully, if you've ever met the defendant, you would probably think that, I'm sorry, my time is up.
You may answer the question.
But you may think that she really is in a bad state mentally. And it was evident upon when she went into court and the actions that she did, that she just was not, she just suffered from mental illness and it needed to be addressed.
Thank you very much, counsel. Thank you both. The case is submitted. And our next and final case of the morning, or no longer morning, is AM versus C.J.M. 2023 P1071. I would remind counsel that the case is partially impounded. Please refer to the parties by status would probably be the best. May I suggest ex-girlfriend and ex-boyfriend?
Good morning, Your Honor. I'm David Ayekoloye, representing the appellant. Your Honor, the case before this honorable court, we see that the Massachusetts District Court had no jurisdiction, precisely subject matter jurisdiction, over this case at the time they adjudicated over the case, right from 2021. All the parties were residents of Bristol, Rhode Island, and every single thing in the case.
Could you repeat that? All the parties were resident where?
Of Bristol, Rhode Island. And every single thing that happened in this case happened in Rhode Island, but the plaintiff came over to Framingham to get a restraining order, which both states are different sovereigns. And not only that.
Just counsel, just so that I'm clear, you're arguing that the parties had moved to Rhode Island before even the initial order was issued? Or the extension?
Yeah, no, what we are saying is that right from the start of the case, everything that happened in the case happened in Rhode Island.
But did the plaintiff live in Massachusetts when she sought the restraining order?
At the time she sought the restraining order, we don't know where she was living, but probably she was living in Massachusetts. But what we are contesting is subject matter jurisdiction. We are not talking about personal jurisdiction, because everything that happened in this case happened in Rhode Island. So Massachusetts has no jurisdiction over this case in the first place.
But you're not contesting personal jurisdiction.
We are contesting subject matter jurisdiction. And not only that, Your Honor.
Is there someplace in the record that shows that all of these events took place in Rhode Island?
Yes, Your Honor. Like, but in the brief, he stated that both parties were in Rhode Island when everything happened. And also, in the brief before the Supreme Court, even the subject matter jurisdiction was raised right there before the district court at Framingham.
Wait, you're saying subject matter jurisdiction was raised before?
Yes.
How do we know that?
But it was raised before the district court. That was in the, that was during the initial extension.
The first extension?
Yes.
So if I'm remembering this, there was an ex parte, there's an extension within a matter of weeks. You're saying it was raised then?
Yes, Your Honor.
That there was no subject matter jurisdiction of the court?
Yes, Your Honor.
And do we have the transcript?
There is no transcript on that, because we are not challenging the temporary, we are not challenging the temporary order, we are not challenging the two renewal, we are challenging the renewal in August.
I understand, counsel, but you're raising an issue that I didn't see in your briefs.
The initial,
let me finish. Yeah. And one which you say was only raised in the first extension hearing. And I'm asking you if you're going to want us to think about this question, which obviously you do. Did you put in the record the place where it was raised before the judge so that we can look at what evidence at that time was argued or presented? Because it seems to me that if I live in Massachusetts, I may well be able to go into a court in Massachusetts and say, I would like a restraining order against this person who lives in Rhode Island. And you haven't cited us any case law on that subject, so I'm just trying to figure out what the facts are, and then we can talk about what the law is.
So what we are basing it on is that everything that happens over in Rhode Island, which...
But that may not matter, right? If I'm a district court with jurisdiction to enter a 209A order, clearly I have jurisdiction to enter 209A orders, right?
Massachusetts, definitely, but
okay.
The condom must have happened in Massachusetts.
Well, who says that? And why would that be a good rule?
Yeah, because...
No, what case do you want to cite me? Are you saying the statute, I can only get a restraining order against conduct that occurred inside Massachusetts? I go shopping with somebody to Rhode Island. They abuse me. I can't come back to Massachusetts where we live and get a restraining order against them?
Yeah, I know that by law, common law and constitution, Massachusetts does not have
I'm sure the
jurisdiction.
Constitution has nothing to say about that subject.
I know that Massachusetts does not have jurisdiction over what happens in Rhode Island, and I can cite...
But it's not a criminal case. It's not prosecuting him for something that happened in Rhode Island. It's trying to protect a plaintiff who lives in Massachusetts, if I understand this correctly.
A plaintiff who lives in Massachusetts, though we are not sure of where the plaintiff lives at the time the order was sought. But what we know is that everything that came up before the judge, every single thing happened in Rhode Island, and the parties were living in Rhode Island at a material time when everything happened. And in addition to that...
In the first hearing, the first extension hearing, the defendant appeared, correct?
In the first extension, the defendant appeared. In the second extension, the defendant did not appear, and the defendant thought that the order had lapsed until the defendant was summoned in August 2023 again, and he was surprised that the order was still intact. So another part of our argument is that the entire proceeding was unconstitutional. It was against the Constitution of the United States, specifically the 14th Amendment. It was against...
Which provision of the Constitution do you say was violated by entering an order on behalf of a Massachusetts citizen to prevent her from abuse?
Due process of law, Your Honor.
Due process, in what way?
Yeah, so because when the case came up before the lower court, the burden was on the plaintiff to present our case, but the plaintiff did not present any case. The court did not follow due process.
The plaintiff presented an affidavit. It's in the record.
The affidavit dated back to July 2021, and there had been 3 extensions after the affidavit. So when the plaintiff was before the court on that day, the plaintiff said nothing. All the judge did was pick the initial affidavit, relitigated it, and based judgment on the initial affidavit. In fact, the defendant was asked to defend himself when the plaintiff said nothing. And as we know, a plaintiff in every case has a burden, no matter how little. But in this particular case, the plaintiff did not discharge any burden. The plaintiff did not present any case. It was the defendant that was called upon to defend himself when the plaintiff had said nothing.
Counsel, I understand that the judge did ascertain that the plaintiff still feared your client, and your client understandably said she has nothing to, I'm paraphrasing, nothing to fear. I've had no contact with her for 2 years. I've moved on. There's no basis for this order. The judge took those 2 versions and decided to extend the order for another 2 years. How is that an abuse of discretion?
Yes, Your Honor, because the law says that the circumstances of a case must be considered before an extension can be granted. In the first place, there was no actual or physical abuse in this case. Right from the inception of the case up till the time extension was granted in August 2023, there was no time the court made any fact-finding that actual abuse happened. And there was nothing before the court that shows that the plaintiff had fear of the defendant. What the plaintiff complained about was that the defendant was following her around sometimes very long ago, over 2 years. And the defendant had stopped following her long ago. And the judge did not put into consideration that for good 1 year, the defendant believed that the order had lapsed. Nevertheless, the defendant did not contact the plaintiff.
Did your client live in Rhode Island throughout this process?
Yes, Your Honor.
So he's been in Rhode Island from 2021 till present?
Yes, Your Honor. And both parties don't live in the same state. They don't live in the same community. They have nothing to do with together whatsoever. The defendant specifically told the judge that he is a friend to the friends of the plaintiff on Instagram, but he never contacted any one of them. I know.
Not required. I mean, the Callahan decision says if there's been actual abuse as to which there was an affidavit of actual abuse, physical harm, then we don't have to show on an extension that she's reasonably in imminent fear. It literally holds that. You do not have to show imminent fear. As Judge Milky points out, the plaintiff did say, I'm still afraid. I don't want to look over my shoulder anymore. I'm glad that I don't have to look over my shoulder anymore to see if his truck's there. Why isn't that enough?
It's not enough, Your Honor, because every case must be decided based on the fact and the circumstances of the case. And in granting an extension, the circumstances surrounding the case must be considered.
Right, but why would we, and your client testified, so both people testified, why would we not indulge in the usual inference, if you will, that the judge considered what both parties had to say against the legal standard that we know was extant, and decided that in the totality of the circumstances as he was aware of them, he should extend the order? Why would we not? What is it about this case that doesn't allow us to indulge in those inferences?
Yeah, what does not allow the extension is because the physical abuse or actual abuse has never been resolved, that it's happened in the first place. And another thing is that the procedure in which
it was alleged that it did happen.
The
judge granted the restraining order. What more do you think was required? A fact-finding that there was actual physical abuse?
There should be fact-finding because the defendant denied every single allegation.
Right, but the case law doesn't say that the judge has to make fact-finding on that, right?
Like, it is essential that a fact-finding is made before a determination can be given.
So that's the due process argument.
Your Honor?
You need a finding on that before you can invoke Callahan 2 years later.
Yeah, before a judge can make a pronouncement on a particular situation, there has to be a reason why such pronouncement is made.
Okay.
And aside from that, it is very important to note that the lower court did not follow any adversarial procedure during the entire trial. And it should be noted that plaintiff was denied his right to cross-examine. The defendant was denied the right to cross-examine the plaintiff, which the Supreme Court of Massachusetts already said is a substantial right when it comes to 209A. And 209A itself is already at the twilight of unconstitutionality. And by allowing this kind of practice, not allowing a judge to follow the procedure, is going to cause a total breakdown of law, because the Supreme Court specifically said that, sorry, Your Honor.
You may finish the thought.
Yeah, the Supreme Court specifically said that 209A can be unconstitutional if it is not properly handled by the lower court judge and the procedure followed. And that was the case we saw in this case, because no procedure was followed, because the judge believed that the order must be extended.
Where did the judge deny cross-examination?
Yeah, the judge asked the defendant to present his defense without asking the plaintiff to present any case.
Well, that's not
And-
true. I mean, I'm looking at it, and the plaintiff did present a case. And then the defendant got up, and the defendant got questioned by the judge. I don't see where the denial of cross-examination occurred.
Plaintiff asked for relief. It was the judge that presented case for the plaintiff. And because the judge presented case for the plaintiff, the defendant lost his right to cross-examine the plaintiff and make the court know that the plaintiff had no reasonable fear of him.
Okay.
Thank you very much, counsel. We will hear from the plaintiff's attorney.
Thank you, Your Honor.
Okay.
Good afternoon. May it please the court. My name is Elizabeth Jorgensen, and I represent the plaintiff appellee, who I will refer to as plaintiff in this oral argument. The issue for review is whether the judge could properly conclude, by a preponderance of the evidence, demonstrated that the plaintiff had a continuing need for extension of her abuse prevention order when appearing before the court in August of 2023. At the August 2023 extension hearing,
I hate to do this.
Yes?
But I would like your views on whether subject matter jurisdiction is an issue.
Well, it's a surprise, Your Honor, as I did not...
Well, you're not the only one surprised, counsel, so...
I didn't see that in the appellant's brief.
It was not.
Or the reply brief. The plaintiff, when filing for an ex parte order and also at the initial two-party hearing, had the appropriate subject matter jurisdiction. She was either living in Massachusetts, working in Massachusetts, and she believed that she met the definition of abuse in that order. And as Your
So
Honor
that's the
pointed,
basis for, look, I don't have 209A in front of me. The basis for subject matter jurisdiction is that she either lives or works here?
yes, the statute, the restraining order says that the defendant has to stay away wherever she may be in the residence line, but you can see that there is an address for the employment where she was at the time.
Well, yeah, but that's just the order itself. I mean, we have to go back and just ask the question, what's the basis for the court's jurisdiction? One basis for the court's jurisdiction would be that this is where the plaintiff lives. Your brother just stood up and said she didn't live in Massachusetts when she sought the first order back in 2021. What do we know about that?
Your Honor, I did not represent the plaintiff
I'm sure you didn't. Do you know anything about it? Have you seen the earlier transcripts by any chance?
Well, the transcript that was provided on appeal is the one from the August 2023 hearing.
Right. Do we have
We do not have a transcript of the lower court proceedings. That being said, as Your Honor...
If she did live in Rhode Island in 2023, is there any evidence as to where she lived?
That information is not a part of the record, as the address, at least by the face of the restraining order, is not disclosed. I don't know whether she made a request for impoundment of her address. Regardless, I would agree with Your Honor's comments to my brother counsel previously that the fact that she was obtaining a restraining order at the time of the initial request and also at the 10-day contested hearing in Natick, practicing in Framingham District Court, that she had met the subject matter jurisdiction. The defendant appeared at the initial 2-day contested hearing and submitted himself to personal jurisdiction.
Yeah, well, at least he didn't raise it as an objection, right? So that's the end of that story, and he's saying he's not raising it now. I wouldn't even know how to start. We don't have a record. What we know is that she presented to the court, and we're told that subject matter jurisdiction was raised, but we have no record of that, right?
I would agree that it's not properly before this court, and the argument should be not considered on because it was not properly before the
we got a
appeal.
lot of cases that say subject matter jurisdiction can be raised at any time, and we need to address it. So we'll have to think about it. but if there's an inadequate record to make that decision, it seems to me that's where we are. Okay, anyway. Why don't you move on to the rest of your argument?
The appellant's brief makes several references to the plaintiff failing to show that she was in fear of imminent serious physical harm. However, the August 2023 extension hearing was based on past physical harm. So in this court's decision 2012 of Callahan v. Callahan, the court explained that when a plaintiff seeks an extension of an abuse prevention order predicated on actual physical abuse, as is the case here, as you can note at the first bullet of her affidavit supporting the abuse, she says that in January 31st, he sent me to the hospital with elbow contusions. The court held, therefore, that the judge must make a determination based on the totality of circumstances that there is a justification for the continuance of the order. And that can be in light of the initial order.
How do we know what the basis for the original order was? We
How
have
do
the
we know
affidavit,
the
but
basis?
it has several allegations in it. How do we know which ones were credited and not?
I would submit to you that it's not important which one was dispositive.
Well, it is, because then it affects the standard for an extension, right?
I think that when the fact that there contains in the affidavit an allegation of physical abuse, and the court is focused at the extension hearing on continuing need. And here, the plaintiff testified that she's still in fear of the defendant, and that she...
But she didn't testify to imminent fear. Isn't Judge Shin right that it would be very helpful for us to know what the basis for the initial order was?
I will concede that the judge here did not make oral explicit findings as to what standard she was using, although I think if you look at the record and based on the sequence of her questions, it is the emphasis on the initial order, on the physical abuse, lack of questioning regarding to the plaintiff about whether she continues to be in fear of imminent serious physical harm. I think that demonstrates that this judge was considering the Callahan holding and was appropriately applying the right burden.
Why can't we just look to the transcript of the most recent hearing where he admits to breaking the door handle and then asked about the split lip? He said he didn't cause that, but then is asked, did you bruise her arms? And the answer is, I have no, yeah. Why doesn't that just establish that we're talking in Callahan land?
I think that also established it. I think that there are many places in the transcript where you can find that the defendant corroborates some of plaintiff's statements in her initial affidavit, and that admits that there was at one point where the defendant states that they used to restrain each other. And the judge asks a clarifying follow-up question saying, so you did place your hand on her?
Which doesn't get answered, as I recall, right?
I'm sorry?
That clarifying question doesn't get answered, if I remember the transcript.
No, it does not.
What do you say, I'm going to bring you back to jurisdiction for a moment. What do you say, and I know you've had no time to think about this, so it's fine, but if you've got something to say, it appears that he may be right, that what was the basis for the complaint about physical abuse all happened in Rhode Island. Does that matter for purposes of jurisdiction? Does it matter for purposes of the court's jurisdiction that what she was complaining about occurred in Rhode Island?
I do not think so. What's important is in protecting victims of domestic violence under the 209A statute is concerned squarely with protecting someone from abuse. And in the actual terms of a 209A order, It considers staying away from a home, staying away from a place of employment, but it also considers no indirect contact through a third party, no communication by telephone, by email. So any of the violations of a 209A order could occur anywhere in the world, and it would still be held
We
violent.
can't have somebody walk in from Arkansas and say, I want a 209A order against my spouse, and we both live in Arkansas. That ain't gonna work. The point is, she lives here, right? But we don't really know that. We're just assuming it to be true. Okay.
I mean, why isn't it sufficient that apparently, according to the order, she worked in Swansea?
Oh. Does it have
Looking at
an
RA
That's helpful.
1-3. Stay away from the workplace, and it names a particular bar in Swansea.
Okay, there we go. Thanks. Thank you, Judge Milky.
My last act.
I'm sorry, Your Honor. May you repeat your question, please?
The question is simply, doesn't this answer it, that there was a connection to Massachusetts?
In terms of the place of employment?
Yes.
It was something that I'd referenced before. Sorry if I hadn't emphasized it to the degree.
So even if it had been true she was living in Rhode Island, she had
working in
cause to
Massachusetts.
seek a restraining order that protected her in Massachusetts.
Right.
I believe that is apparent from the face of the 209A order as an initially ordered at the time of the ex parte order and then at the initial two-party contested hearing.
So venue is where the plaintiff's residence is, right?
It doesn't have to be. You can go to a different location outside of the plaintiff's residence under the statute.
Well, Section 2 says venue is over the plaintiff's residence, right? But if the plaintiff has left the residence because of the abuse,
You can go from where the abuse has occurred or the plaintiff's residence. The idea is to give as many venues as appropriate so that you
presumably,
can
though,
seek
then-
protection.
presumably, though, then she had a residence somewhere here.
I'm sorry, say it one more time.
Presumably, then she had a residence somewhere in Massachusetts.
I believe that she had a residence in Massachusetts.
Okay.
But in any event, Swansea is in Bristol County. We can agree on that.
I'm sorry, say it one more time.
Swansea is in Bristol County.
Your Honor,
It is in Bristol County.
I'm happy to submit any post-argument briefs, and we could work together on getting a transcript of the initial order hearing.
Please, I say this to both sides, no submissions unless we ask for them.
Okay. I would say, just in a conclusion on that point, the defendant has not raised subject matter jurisdiction in the context of the appeal that is relevant here. To the extent that it was raised and considered by the 10-day contested hearing, then I would suggest that was fully considered and that this is just not appropriately before the appeal court today. And as
What evidence is, that's a good point, but what evidence is there in the record to indicate that she lived or worked in Massachusetts when she sought the extension in 2023?
before this court, with the transcript that was provided by the appellant, you do not have that answer.
Okay. Did she get an extension order in 2023 that still listed the same workplace?
I'm sorry, say it one more time, Your Honor.
Sorry. Did she get an extension order in 2023 that still listed the same workplace in Swansea?
There were no modifications in 2023 to the order.
Okay.
I have no further comments, so I would be happy to rest on my briefs if there's no further questions.
I think
What
Judge
would
Englander's thinking about it.
Yeah, I am. What would you say is the evidence in the 2023 transcript that shows the continuing need for the order previously entered?
What was the evidence in the 2023? I think that it was evident by her testimony that she was in fear of the defendant and that she was still looking around because of the instances of stalking that she was raised in the initial affidavit, and that she was seeking the court's protection so that she could feel a sense of safety as she goes about her daily life.
Counsel, thank you very much. Thank you both
Thank you
very
for your
much.
time.
The case
Thank you for your
is
questions.
submitted. That concludes our sitting today. Our thanks to the court officers, to the clerks, to former law clerks, and we are adjourned. Thank you.
All rise. This court will stand in recess.